Tender. Obviously.
May I please, Your Lordship? Lordship, the concern of the other side, I beg to mention, I don't know, 47 to 62, Your Lordship. I'm praying on behalf of Mr. P.N. Goswami, additional AG.
Huh?
I'm praying on behalf of Mr. P.N. Goswami. Lordship, let the matter be taken up after vacation. We are still
You have not yet come in. It's with regard to royalty.
royalty, Your Lordship.
The first paragraph of the directions, first 4 lines. The direction of this court is that a decision has to be arrived at from the conditions of the tender, whether there is a requirement for payment of royalty. Now, why that decision has not been taken? That decision is not for you to take. That is for the concerned work allotting authority.
PWD.
Why they have not taken? Once they take that decision, then the other decisions kick in.
Yes, Your Lordship.
Now, without arriving at that decision, they write a letter that the petitioner has not given documents. How can that be sustained? And it's a 18 matter.
Yes, Your Lordship.
I'm sorry, we are not in a position to it. And you don't have any rule now, presently, at least. Why the PWD is dilly-dallying the matter? That decision is the only thing they got to take in the context of the conclusions reached by this. That's all. Once they take that decision, arrive at a conclusion that yes, in the terms of the contract, a forest royalty is required to be paid. Then the issue would be whether he has given the document.
Right.
You're putting the cart before the block. I think we'll have to hear the PWD, whoever it is. Mr. P.N. Goswami, we will accommodate it, don't worry. But where is the... Have you informed the PW also that you are taking time?
The PWD is there, Your Lordship.
Who is appearing for the PWD?
Lordship, Mr. B. Gogoi appears for the PWD.
I'll inform us. We are aware of this case, Lordship.
Any decision taken?
Lordship, no. Lordship, what had happened, prior orders of this Honorable Court, coordinate benches of this Honorable Court, have made Senior Counsel Mr. P.N. Goswami has been made party so that the matter can be expedited. In orders, they could not have deducted the forest royalty, Lordship. That is already a settled principle.
Hence, the only thing is, if forest royalty is to be paid
Lordship,
in terms of the contract, then you will have to demonstrate that you had paid it. And then the verification from the forest. To that extent, maybe the forest is to be involved. Otherwise, what is the beauty in getting the forest here?
Lordship, what had happened is that we had not directly paid. The amount was deducted from our bills, Your Lordship, from the running bills of the petitioner. When the work was being done, the forest royalty deductions were there. When we had asked why that money is being deducted.
That's it. For that, the decision has to be taken. There has to be a deduction of forest royalty. That has not been done.
Lordship, deduction has already been done.
No. Have they taken a decision that in terms of the contract,
Lordship,
a deduction is to be made?
Lordship,
They have taken
in the writ petition, they have already stated that in terms of the contract.
No, in the terms of the direction.
By this, in the contempt case, Your Lordship.
No. In the order, original order. Para 41, 1, 4 lines.
I'll have to look through, Your Lordship.
May I?
When both of you are not...
My Lord, I am there, my Lord, and for the petitioner, my Lord. My Lord, on the earlier occasion, my Lord, in this contempt proceeding, his permission was made.
Oh, fine. We'll go by that. But my view is that the decision that is to be taken by the PWD, that yes, forest royalty is to be deducted, that decision I don't find in the record.
But as per the last order, the PWD submitted, they have collected the forest royalty and deposit with the forest department, Lord. That's
PWD has already deducted the forest royalty amount of forest.
Whether that deduction is permissible in terms of the contract.
Yes, my Lord. In time, there is no contender condition.
That's what.
Allowing them to.
That is the decision this court required.
Yes, my Lord.
In para 40, last paragraph.
Last para, my Lord.
First 4 lines of that.
Yes, my Lord.
Anyway, if you're not interested, we'll adjourn it.
My Lord, we have some emergency, my Lord.
On the prayer of a prayer is made on behalf of Mr. P.N. Goswami, learned Additional Advocate General, learned counsel appearing for the
forest department.
No.
Additional AG.
Additional AG appearing for the any respondent in the forest department.
My Lord, in contempt petition, there are no respondents, my Lord.
Okay. Additional AG forest department. Additional AG appearing for the forest department. for an adjournment in the matter on account of personal inconvenience. When is he coming back?
He's here, Lordship, but we need some instruction in this matter, Your Lordship. This, we have to go through all the records.
Also, prayer is made on behalf of Mr. P.N. Goswami, an additional AG for an adjournment in the matter to complete his instructions. Also, prayer accepted. Registry to list this matter again on 15/6/2025. Please look into that 4 lines.
Yes, my lord.
Whether there is a decision. If there is no decision,
Yes, my lord.
then a contempt is clearly made.
Yes, my lord. There is no decision, my lord.
Published.
May I please to Lordship? Lordship, I have filed this writ petition yesterday. I am praying for listing for motion tomorrow.
What is the urgency?
Lordship, because this is an appeal matter and
PDCL matter, we got it. Is there a shock coming?
yes,
There is a,
Lordship,
what
because
is the matter?
because the APDCL has already issued a final show cause notice for blacklisting me. That's why this is the urgency.
Blacklisting show cause. Reply
Yes.
to that.
Now, I have already replied.
Then they'll take a decision. That is the requirement, that there has to be a show cause notice. And thereafter only a blacklisting can be done.
Yes.
Now that they have given you a show cause notice, why should we interfere in that matter at this stage?
Maybe tomorrow, Lordship. Friday?
Monday.
Lordship, Friday, maybe Friday, Lordship.
Friday. A motion day Friday.
Yes.
Friday.
Much obliged.
Lordship, Lordship, I beg to mention item number 4, Lordship.
A prayer is made on behalf of Mr.
K. Mujumdar,
You are making a mention for?
petitioner K. Kolita.
Huh?
For petitioner K. My
K.
senior is K. Kolita.
What happened to him?
So Lordship is out of station, Lordship.
A prayer is made on behalf of Mr. K. Kolita, learned counsel for the petitioner, for an adjournment in the matter on account of person inconvenience. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again after 2 weeks on a date.
May I please, Your Lordship? My lord, I beg to mention item number 38, my lord.
30?
38, my lord. And, paying for a short accommodation, my lord.
Huh?
Paying for a short accommodation, my lord.
Why?
Not some difficulty today, my lord. Today,
Optical fiber link.
my lord, my lord.
Your name?
F.L.
Malik.
Oscar.
Huh?
F.L.
F.L. Oscar. A prayer is made by Mr. F.L. Oscar, learned counsel for the petitioner, for an accommodation in the matter today on account of personal inconvenience. Prayer accepted. Registry to list this matter again on 17/6/2025.
Lordship.
Maybe, my lords. My lords, I beg to mention item number 64, my lords, with the
64.
consent of the respondent number 1, my lords.
Huh.
My lords, I'm praying for some time to file my reply to the affidavit in opposition, my lords.
3 months.
No, your lordship.
No. 3 months.
3 months is the issue.
In lieu of 12 months.
Yes, my lord.
But 126(5) says 12 months.
If it cannot be ascertained, it has to be limited.
Well,
In our case, it was, we have established before the appellate authority that it was, it could have been ascertained.
Ascertainable.
They have caused an inspection, they install a.
But your malpractice was upheld. Commission of malpractice was
Yes,
upheld.
only thing that we have not challenged, we have not filed a
No.
PROCEED. But we can satisfy even otherwise, when the modem was installed, they opened the thing, from the date of that will be construed as the last day of inspection, and that comes to 3 months.
No, but from when was the thing being?
No, the thing was that there was a tampering with the wire. To install the modem, you have to open the entire case. Had there been a tampering of the modem on that day, they could have very well noticed it.
Mr. B. Chaudhary, learned counsel for the petitioner, is that he be granted
3 weeks time.
3 weeks time to file rejoined to the affidavit filed by the opposite party number 1. Prayer accepted. Registry to list this matter again after 3 weeks on a date to be fixed.
Well, there is an interim order, my lords.
Interim order passed earlier to continue till the next date of.
The-
For the 3 months, have they paid the money?
We have paid, rather we have to get a
Get it back.
refund back.
To get it adjusted.
No, that they are not doing, we are willing for that.
Yes.
Can I pray for a date?
3
20th
weeks.
of July?
When, raised for 3 weeks time. So accordingly, registry to list this matter again on, as agreed to by the Learner Council for the parties, registry to list this matter again on 20/07/2027. Yes,
Yeah, please,
yes,
I beg to mention for listing of IA lordship. I pertain to lordship correction of order lordship.
this court sort of.
Lordship.
Tomorrow.
Right. Friday lordship.
May I please,
Yes,
Your
ma'am.
Lordship? Lordship, I beg to mention on WBC for admission, any date in next week, Lord.
Lordship, may I mention item number 27, Your Lordship? Here, a mediation report has come. I have gone through the office note and by the report dated 8/12/2025, office
20?
to 8/12/27.
Huh.
Matter was sent for mediation and mediator has sought for 30 days more time. It was of 8/12/2025, office note.
But this matter has come up today before this court.
Yes, and then thereafter what had happened
No,
after
no,
1 month?
there was no time given because this court has to give the time. Now, Madam Bhuya, you
My
tell me,
Yes,
you were asking for retirement benefits.
yes, not
You-
retirement.
GIS,
Lordship, actually, yeah. Lordship, and for certain period, that benefit has not been, yes, my lord.
you had asked for GIS, leave salary,
Yes,
pension,
yes,
and for a particular period,
yes,
the salaries. Now, GIS has been released to you. Leave salary has been released to you. Now, the only thing left is that contention of yours that while you were working as a superintendent, you were being given the pay of inspector. While working as additional director,
my lord.
you were being given the pay of the
Super-
inspector.
Yes,
Now, you have made all these statements. When were you promoted?
oh, lordship. Actually, I have got all the relief except payment for a certain particular period, which
Why
was,
keep this matter pending? We will remand it back. You approach the authorities, we will put a time frame. Within that, they
lordship, what my client is informed last evening, then she might get the benefit in a period or two. So may I submit this
on
matter
the
may
order
come
of
up?
this, we learned counsel for the petitioner. Registry to list this matter again on 17/6/2020.
Lordship.
Nothing is left here.
My lord. Repeatable, huh? Applies to.
Yeah. Yes.
May we please, Your Lordship?
Hmm.
My lord, kindly peruse the last order dated on 24/4/2026, my lord.
I know.
Yes, Mr. Otto.
Lordship, let's receive some instruction, Lordship. They are seeking 4 weeks time to disburse the amount, Lordship, to the district commissioner.
Mr. Osa, they are giving it to you in 4 weeks, wait for 4 weeks. But this M. Purmi, learned counsel for the petition. Also heard Mr. S. Dr. learned counsel appearing for the respondent. In all these cases, the same order would be there.
Lordship, 1, 5 and 6.
Item number that is,
Yes.
1 or 2 matters are there.
5 and 6.
5 and 6.
5 and 6.
5 and 6. Belek can make, no? Osa, in pursuance to the order dated 24/4/2026, Mr. Dr. has placed on record the instructions received by him. Dated 2/6/2026. On a perusal of the said instructions, the respondents in the Revenue and Disaster Management Department have prayed for further grant of further 4 weeks' time to disburse the fund, disburse the dues receivable by the petition. So, in view of the above development taking place in the matter, this court adjourns the matter today and directs the registry to list this matter again on 15/7/2026. On the next date of listing, the respondents shall place before this court the compliance report after having released to the petitioner the dues receivable by him in pursuance to the directions passed by this court While judgment and order dated 23/7/2025 in WPC number 6859/2024. Next to Khalid change. A copy of the instructions as furnished by Mr. S. Datta is kept on record and marked as X for department.
Much obliged.
May I please, your lordship? Order dated 6/8/25, relevant portion, page 28.
They have done nothing.
Nothing.
But Mr. RJD's learned counsel for the petition. The present contempt petition has been instituted alleging violation of the directions passed by this court while judgment and order dated 6/8/2025 in WPC number 5247/20. Issue notice. Petitioner to take steps for service of notice upon the respondents, by way of speed post, steps within 3 working days. At this stage, the personal appearance of the respondents are dispensed with. Registry to list this matter again after 4 weeks.
Deeply obliged.
May it be please, your lordship? My lord, my lord, the relevant portion is page 16, my lord. Non-compliance of the order dated 3/11/2025, my lord.
Heard Ms. M. Kurmi, learned counsel for the petition. The present contempt petition has been issue notice. Petitioner to take steps for service of notice upon the respondents by way of speed post, steps within 3 working days from today. Dispense with. Next to okay.
Next, my lord, the order dated is 23, my lord.
Next 10/11.
8/11.
9,
10/11.
8, 9, 10,
11.
11. Safe.
Much obliged, lord.
Yes, Mr. Som.
My lord, non-payment of withheld amount, my lord, after completion of the works. I have submitted the bill has been prepared.
Mr. Gugoi, you are appearing for all the respondents?
At this stage notice, Lord.
Huh?
At this stage notice.
Naturally. For all the respondents?
Lordship, up to all the respondents, Lordship.
All the. Heard Mr. N. Sharma, learned counsel for the petition.
Vote into it. To vote into it.
Also heard Mr. K. Gugoi, additional senior government advocate.
Where is vote tonight?
You are standing counsel.
Additional senior government.
And additional senior government advocate appearing. For
Lordship, in respect of 1, 2, 3, and 4 notice have to go. Board is there.
Sure is board.
Board is there, Lordship.
Oh, yeah, okay.
Board is
In
there.
respect of, also heard Mr. K. Gugoi, learned additional senior government advocate. So. The petitioner in the present proceedings have prayed for a direction upon the respondent authorities to release the withheld bill, release his withheld bill amount of rupees 12,75,039. Words of appeal. Huh? Which is receivable by him in pursuance to the successful execution of the works allotted to him. Also, issue notice. Mr. K. Gugoi, learned additional senior government advocate, accepts notice on behalf of respondent number 1. No formal notice, no? Petitioner to take steps for service of notice upon respondent number 2, 3, and 4. Steps within 3 working days from today. Also, registry to list this matter again after 4 weeks. On a date.
Deeply obliged.
May I please? My lord, this is for non-payment of contractor's bill, my lord.
You are Mr. N. Hop.
K Uddin.
K Uddin, K Uddin. It will hobo, amount hobo.
Amount is valued 8,75,000.
8,75,000. Mr. S. Dotto
For appearing for respondent number 1 and 2.
for 1 and 2. Report khali likhiba S. Dotto. Steps 1 and 2. S. Dotto. Any more? Mr.
M. Bhuya, Lordship.
No. Mr. K. Gogoi, 3 and 4. And Miss M. Bhuya, Mr. M. Bhuya, 5. 14 ta naam likhiba, notice 18 ta is. No formal notices.
5.
Raised after 4 weeks.
My lord, item 17 is also same.
17.
Yes, ma'am.
Amount?
Amount is, my lord, 14 lakhs. My lord.
14 lakhs. Full, no
Full,
breakup.
full, my lord.
Okay.
14 lakhs, huh? 1, 2, S. Dotto, 3, 4, K. Gogoi, 5, M. Bhuya, 6, Standing Council Finance,
Lordship, I can only
5 and 6, Mr. M. Bhuya. Appearing on behalf of Mr. B. Gogoi, Learned Additional Advocate General.
Okay.
Only 6 respondents?
Yes.
Yes, ma'am. Fix it. Obliged.
Right, please, Your Lordship.
Hmm.
I have 3 grounds, Your Lordship, for the cancellation. One, that it prejudice.
What do you say about Ma Bidda? Practically same situation. This court said, this court division single bench interfered with that. Division bench reversed that. Matter was taken to the Supreme Court. Same. Because the exact projections that were required to be made in the MIT was not made. Here, I got it, that the tender committee once approved, again, it reapproved, if I may use that word. But the reasons given is that, see, this is a work which is to be done in a mountainous region. The sloping work, all those things have not been taken care of, have not been factored in properly. So, is that not a reasonable explanation?
It was in the context of similar work. And the tender committee subsequently comes to the conclusion that
Even
I
if
have also.
You go through Ma Binda, you will find a simile there. And your tender, this validity has come to an end.
Today.
Today it has come to an end. And how can we direct that the validity be extended? Can we do that? Or you
Yes,
can be-
Your Lordship, because the Supreme Court now, with regard to the validity of the thing is one aspect, but the Supreme Court in a very latest judgment, Your Lordship,
What is that?
Golden Food Products,
Hmm.
that is on 6/1/2026.
What is the ratio?
The ratio is that para 28, in our view, there cannot be any impetus of the court to such arbitrary cancellation of auction by instrumentality. I'm reading your Lordship may just start from para 27 bottom.
Having regard to discussion, the High Court was not right in dismissing the petition. In our view, there cannot be any.
There. That was with regard that no right has been accrued in my favor. Then, in our view, there cannot be any to the search arbitrary by said in the absence of there been any fraud, collusion, suppression, etc. Merely because the smaller plot, this was with regard to that they were contemplating of getting a higher rate. Then para 29 also may be seen. There was no reason attributed for the cancellation of the auction sale. In the circumstances, the appellant had a legitimate expectation to receive an allotment letter with the subject plot as it was the highest bidder. Instead, without any prior notice to the appellant, the auction itself was cancelled, which constrained the appellant to approach the High Court. Then 31, all the case laws are being discussed. And in the 32 may be seen, Your Lordship. An auction process has the sanctity attached to it and only for valid reasons that the highest bid can be discarded in an auction which is otherwise held in accordance with law. If a valid bid has been made which is above there should be a rational or reason for not accepting it. Therefore, the decision to discard the highest must have a nexus to the
But
rational.
this decision, we did not take into consideration Mabinda. Mabinda, the exact opposite conclusions are there. 2014 4 SCC, 14 4 GLT SC1. I just missed out the bidders participating in a tender process cannot therefore insist that their tender should be accepted simply because a given tender is the highest or lowest depending upon whether the contract is for sale. All that the participating bidders are entitled to is an equal, fair, non-discriminatory treatment. So and so, so and so, so and so, so and so.
There's another decision, Your Lordship, no doubt, by our.
We'll examine it. Yes, Mr. Gupta.
My lord, a decision has been taken by the railways, my lord, in
But see,
106.
your expert committee, which is your tender committee,
My lord.
it twice recommended the case of the petitioner with the given
But the final decision,
conditions.
with the accepting authority, my lord, finally.
Where is the reasons for the accepting authority rejecting it?
It is there, my lord.
Come
Page
to
107.
And
My lord,
this
page-
BOQ revision is subsequent.
My lord,
Yes.
page 107, my lord. The tender is discharged with the remarks. The tender condition for BAQ as well as EPC tenders have been revised by the Railway Board recently. And there is a significant change in that. A presentation has been made recently regarding various slope protection measures and their durability. The efficacy and durability of the proposed work in the present tender need to be critically reviewed and suitably revised. There is a confusing similar nature of work defining
And
language.
thereafter, this matter was again considered by the tender committee.
Your
Yes.
Lordship, just
That is confirming.
page 107, Your Lordship, may just see the top portion, decision. Your Lordship has just read the reasoning given. Prior thereto, just that line, decision, TCR accepted for retender. Now, what is the TCR recommendation? That Your Lordship will find at page 106, para 7.3. It is recommended to accept the lowest valid offer made by the so and so. So the TCR never.
Never recommended.
So his very basis on which he has approached for
Now, what
retender.
do you propose to do? Are you proposing to retender this?
Yes, my lord. But I may just further read page
What
107.
you have said somewhere that this will now again require a total reframing of the
My lord,
the
my lord, that is there.
DPR, if I can call
My
it.
lord,
Now that will take some time.
my lord,
You file your affidavit by next week.
my lord, my lord.
Till that time, don't retender. Till that time, don't retender. We'll have to examine this.
Lord, my lord, we'll keep it till the returnable date, my lord.
Only till
Subject
the
to
returnable
further affidavit.
You file
My
your
lord, will
affidavit.
make it clear that it will.
We will take it. And if you don't file it, you get on instant.
My
That's all.
lord.
Heard Mr. D. Senapati, learned counsel for the petitioner. Also heard Mr. A. Gupta, learned CGC, appearing for the learned CGC. The petitioner in the present writ petition has assailed the decision arrived at by the tender accepting authority to discharge the tender. It is submitted that the decision of the tender accepting authority to discharge the tender is contrary to the decision arrived at in the matter by the tender committee. It is also projected that after the said decision was arrived at initially, after the decision of the tender accepting authority was initially arrived at, the matter was again considered by the tender committee and its earlier decision was reiterated for award of the contract to the petitioner. However, such decision was thereafter again reversed by the tender accepting authority on 12/5/2026, right?
Right.
Being agreed, the present writ petition has been instituted. The issue arising in the present writ petition would be as to whether the reasons assigned by the tender accepting authority for discharge of the tender would constitute a valid ground for discharge. The issue arising in the present writ petition is as to whether the reasons assigned would be a valid ground for by the tender accepting authority would be a valid ground for discharge of the tender in question. Also, Mr. D. Senapati, learned counsel for the petition, has relied on a recent decision of the Honorable Supreme Court in the case of Golden Food Products India versus State of Uttar Pradesh and others, reported in 2026 SSC Online SC 24. You want to rely on Mabinda?
My lord.
Okay, forget. Also, Mr. H. Gupta, learned counsel for the respondent, submits that he would complete his instructions in the matter and file an affidavit on or before. Give me a date.
My lord. Is it in June? On or before, my lord, 8, my lord.
8/6. 8th of June.
My lord.
I'll give it till 10th of June.
My lord.
On or before 10/6/2026. Also, you will want a week's time.
Yes, Your Lordship.
The petitioner thereafter is given time till 16/6/2026 to file a rejoinder thereto. Registry to list this matter again on 19/6/2020.
Your
18.
Lordship, can it be on 24th?
No, 18. You are here on 18.
17, I'm here.
17 on 17/6/2026. The issue arising in the present proceeding would require a further deeper consideration, which would be now permissible to be made after the respondents have brought their stand on record by way of filing. Also, accordingly, till the next returnable date, that is 17/6/2026, the railway respondents are restrained from issuing any fresh tender with regard to the work involved in the present proceedings. And we have not touched with the validity. Validity is extending today. Mr. Senapati can always argue that he having come up before this court today, the validity automatically stands on.
The further extension will be reviewed, my lord, by interim order.
Oh,
Otherwise, my lord,
this
that
is
will-
only till the
but that
order
will-
extension of the present order would be so considered after
the affidavit.
hearing the parties on the response on the pleadings in the matter being complete.
Much.
Issue notice, returnable 4 weeks, Mr. Gupta, all respondents, huh? You check up Mabinda,
My lord.
2014 1 4 GLD,
My lord.
SC 1.
There's another judgment. Can I just place it?
Yeah, please. Always welcome.
This is by Justice Chandrachud.
Hmm.
This is on 9/7/24.
Your earlier one was 2026 SSC online SC
24.
24.
24, and this is
This is citation to citation. SSC.
2014 24/15 SSC.
Yes, 461.
It will file to
127, 128. Basically talks about
And keeping this back, I've made a note. I'll go through it.
market.
Got to upgrade myself bit in this line a bit.
There has been a change.
Shift, I know. Yes, Mr. Goswami.
Well, they had filed an objection against opening of a shop.
Huh?
They filed an objection against opening of a shop. Then objection was withdrawn. Now they have filed this case saying that the withdrawal is not
No,
correct.
there is nobody to object to your objections.
Some other day, man. I have all the instructions.
Now tell me one thing, whether it's a panchayat or
No,
a municipality.
It's a municipal. I have certificates from the
So it's 150
150,
and they themselves say it is
200,
250.
250 and 200. So even on merit, also,
None appears for the petition on call. Mr. P.N. Goswami, learned learned senior counsel and additional AG, appears on assisted by Mr.
R.R. Gogoi.
R.R. Gogoi, appears for the respondents. Registry to this matter again on 12/6/2026.
We have a certification from the municipality that it's under
It's the only area where some doubt could have been there. Others, they themselves say 250.
250. So it will be 150.
150. Now, what about the highway? You say 2 kilometers.
2 kilometers.
They say just on the highway.
It's the report says 2 kilometers now.
Your report. But what is the factual position? The photograph says that the highway is just there.
Well, if we go to that aspect, my lord, there is a judgment of the Honorable Supreme Court in 2016. That judgment finally, my lord, allowed the areas that are in transitional phase from panchayat to rural, urbanization. Those were allowed, my lord.
But they see there is no such thing here.
If it is absolutely not developed or not urbanized, then
No, if it is,
and it is on
if
highway,
it is
then
within a municipality, we will have to deem it to be urban.
yes, in municipality, my lord, that was excluded, my lord. That
Excluded.
200, 500 meter criteria.
That was excluded.
I recollect because I was there in the Supreme Court, my lord.
I know those matters were going on. You had told me this that time.
Yes, my lord. Yes.
Okay, fine.
Well, let it be on. Can it be on 11th, my lord?
11, no,
Oh.
11 is Thursday. 10th?
10th, my lord.
10,
Obliged.
16. Yes, Mr. Goswami, what brings you here? Which one? Okay.
May I please, your lordship?
Hmm.
Lordship, this matter pertains to lordship non-payment of some.
You are J. Abbas.
Lordship.
Amount
PNRD, amount is 26,36,000.
26, 36, 446.
446.
Okay, Agonista. And
There are other three connected matters also, lordship. Thing.
who is appearing for Panchayat?
Lordship.
Your name?
Thapa.
Huh?
B.
B. Thapa.
My lord, there seems to be some dispute regarding the project, my lord, at page 39, my lord. The
Maintainability
project
regard.
is not approved, my lord.
But
But there is an administrative sanction given for this somewhere. I saw that.
The district authority said that.
That you come up.
report is also there on next page, lordship.
Technically approved sanction. There is a sanction from some authority here at page
Yeah.
24. Same work.
And lordship, and next page 40, lordship, that report is also there, lordship.
Now you tender it, you get him to work.
Lost.
Now can you come and say that, oh, this is not within the four corners of MREGA? Fine. Miss P. Chakraborty, Learned Standing Counsel, Water Resources. Miss P. Thapa accepts notice on behalf of respondent number 1,
One.
2,
4,
4,
5,
4,
6,
6, 5
5, lord.
by Mr. K. Gogoi.
6.
Me anaka likha. P. Thapa, Panchayat and Rural Development. A. Gogoi, Additional Senior Government Advocate. And Ms. P. Chakraborty, Learned Standing Counsel, Water Resources. P. Thapa 1, 2, 4, and 6. A. Gogoi 3. And P. Chakraborty 5. 4 weeks, huh?
Obliged, lordship.
Registry to list this name, matter again, showing the name of G.A. Assam.
May I please, your lordship? My lord, this is, my lord, regarding non-payment of admitted amount of contractor's bill, my lord. My lord, page
Heard
22.
Mr. AFNU Mullah, Learned Counsel for the petitioner. Also heard Mr. Ms. P. Chakraborty, learned.
Here, my lord, this is not admitted amount, my lord. Lordship, there is.
Oh, file
My
a,
lord,
file an affidavit, that's all. Yes, come with the case, let him have a note.
my lord.
P. Chakraborty, Standing Counsel, Water Resources Department, and Mr. M. Bhuya, learned, Standing Counsel, Finance Department. Ms. Chakraborty accepts notice on behalf of respondent number 1, 2, 4, and 5, M. Bhuya, for 3. So represented. 4 weeks.
Published.
1, 2 also I'll accept, my lord. 1,
1, 2,
4 and 5.
4. 1, 2, and 4. Yes.
Order. In this matter, we have challenged the order dated 13th of April 2016, to 26, regarding debarment order, my lord. Petitioner therein, my lord, has a registered micro, small, and medium and company, my lord, and my lord.
This is an order of
Debarment.
13-4.
Yes, my lord.
You have come now.
26, my lord. And without any so-called notice, my lord, that the debarment order has.
Yes, madam.
My lord.
Lordship. Lordship, I don't have the fact, Lordship.
Huh?
I don't have the instruction, Lordship, regarding this matter, Lordship.
Then we'll state. You are appearing or Mr. Dotto will appear?
Miss Egan will appear, Lordship.
Again. Oh, this is central government.
Sure.
Okay. But Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Ms.
P. Rabha.
P. Rabha appearing on behalf of Ms. A. Gayan, CGC, body. Respondents. The petitioner in the present petition has presented a challenge to an order dated 13/4/2026 by which the petitioner firm has been debarred from participating in any procurement process of the department for a period of 2 years from the date of issue of the said communication. Mr. A.K. Sharma, learned counsel for the petitioner, has contended that the said department order dated 13/4/2026 was not preceded with any show cause notice requiring the petitioner, informing the petitioner about the decision arrived at by the respondent authorities to debar the petitioner firm from participating in the tender process. Also, in view of the issue notice returnable 4 weeks, Ms. P. Rabha, learned counsel, appears, accepts notice on behalf of all the respondents. No formal notice. Huh? GEM portal also you will appear? GEM. So, considering the submissions made by the learned counsel for the petition with regard to the steps preceding the issuance of the debarment order dated 13/4/2026, this court directs that till the returnable date, the debarment order dated 13/4/2026 shall remain in abeyance. And madam, we have kept it in abeyance. Now don't go and demonstrate, display that in your GEM portal. If you have displayed it, remove it from there.
Petitioner here is, my lord, aggrieved by an order of termination of contract as regards
Same
to-
thing.
There are 2 orders that your lordship had given, 2 sets of cases, my lord. Maybe
I
Gaman
think this
Sarkar,
will- This will.
Helang form will not be applicable, my lord. To apna, K. Talukdar had argued, my lord. Your lordship had issued notices.
No, here there was no earlier proceeding in this court. There was no earlier proceeding. So Talukdar I rejected because the interim orders were rejected in the earlier.
There,
order.
true, my lord, true.
In his case,
My lord.
the last date was around 13 or 14. 4 months.
Yes.
4 months.
16.
15-1.
15-1.
Yes.
He completed his transfer of RC.
Pesto
before.
was 3 days.
Peso was delayed by 3
3
days.
days.
True, man. Then I'll leave it to you, lord.
That Lima Akum case will be covered.
But Mr. E.N. Goswami, learned counsel for the learned senior counsel appearing, learned senior counsel assisted by Mr. K. P. Pathak, learned counsel appearing for the petitioner, also heard Mr. M. Sharma, learned standing counsel, Indian Oil Corporation, appearing for the
1 to 3 months.
Corporation, Indian Oil Corporation, full stop. The petition in pursuance to a tender notice dated
1/3/2025.
1/3/2025, read with the corrigendum thereto, dated
6/4/2025.
6/4/2025, had submitted his bid for operating tanker trucks under the respondent number 1. So the tanker trucks as submitted, offered by the petitioner, also included how many in the first one? 2. First one, first case?
Total 12, my lord.
No. Under ATS category, 2.
Two.
No, all of them are.
But only
Except
one
one.
was mine, my lord. It was permissible. Rest were others, my lord.
No, how many are there here? In
Here 2, my lord.
Here
In
there
respect
are
of
2.
2 trucks, my lord, I could not obtain the.
Including 2 trucks offered under the agreement to sale, bracketed ATS category. So the bid of the petitioner being found to be suitable, and the trucks as offered being considered to be so offered under the own truck category, the petitioner was issued with a letter of acceptance
16/9/2025.
16/9/2025.
Followed by work order dated 27/9.
So the said letter of acceptance required the petitioner to complete the process of transfer of the trucks offered under the agreement to sale category within a period of 4 months from the date of issuance of the same. Thereafter, the petitioner was issued with a work order dated 27/9/2025. It is seen that the transfer of the registration of the trucks was completed within the period of 4 months as mandated under the letter of acceptance issued to the petitioner. However, the PESO license of the trucks, set to trucks, however, the transfer of the PESO license with regard to the set to trucks, tanker trucks, to the name of the petitioner had occasioned marginally after the completion of 4 months.
3 days.
Marginally after completion of the lapse of 4 months from the date of issuance of the letter of to the petition, LOA to the petition. Also, the petitioner not having fulfilled the tender condition for having the transfer along with the transfer of all other licenses in his name within the period of 4 months from the date of issuance of the LOA, show cause notice dated 5/5/2026 came to be issued to the petitioner. Also, the tanker trucks as offered under the ATS category also came to be suspended. The petitioner replied to the said show cause notice on 9/3/2026. Thereafter, the respondent authorities, by order dated 12/5/2026, have proceeded to reject the claim of reject the contentions raised by the petitioner in his said show cause reply dated 9/3/2026 and cancel the LOA issued in respect of the said 2 tanker trucks offered by the petitioner under the ATS category. So, being aggrieved, the petitioner has instituted the present writ petition. The learned counsel for the parties have submitted that the learned senior counsel for the petitioner has prayed for an interim direction. Also, the learned counsel for the parties have submitted that the interim prayer as prayed for by the petitioner in the present writ petition would be covered by the directions passed by this court-wide order dated 26/5/2026 in WPC number 2746/2026. Messrs. Messrs. Lima Akum versus Union of India and others. So, accordingly, in view of the above submissions, this court directs that till the next returnable date, the respondent number 2 corporation shall not make any alternative arrangement insofar as the 2 tanker trucks offered by the petitioner, with ATS condition. It is further provided that if it is so necessitated, the respondent authorities are at liberty to utilize the said tanker trucks offered by the petitioner. How such utilization would be without prejudice to the rights of either of the parties. You want that? Maintain the other part.
That, my lord, will take it up.
Oh, that's it there. So, registry to list this matter after 4 weeks. And what about the next one? There's one more. No, only one. So, I thought there will be 2, 3.
This is my first private brief, my lord, after a designation. Deeply obliged, my lord.
Oh, congratulations.
Deeply obliged.
And a heavy one.
Deeply obliged.
Mr. Chaudhary, there are lakhs, crores. The poor lady, 61,000, she is running
the
a...
electricity connection has been restored, my lord.
Ah,
So
you better.
yes. As far as I have to be, my lord, frank and honest with the honorable court, my lord. The procedure is prescribed under 126, perhaps has not
been followed.
The provisional assessment has to follow an order issued to them, giving them opportunity to be
Objections.
heard. Objections. Then
And
a
that
final
has been-
assessment.
You have
Yes.
done nothing.
Yes, that has not been.
And see,
So,
you're
my lord,
this, come to 23. I'll not trouble, sir.
My lord.
You come to page 23B.
23B, my lord. Yes, my lord.
During inspection, category violation was found.
Yes.
How will the person understand what is the category violation?
A domestic
I know that.
connection, my lord.
That's for you,
Yes.
an expert to know. How will the poor lady staying in a house know that there was a domestic connection given it was used for a commercial purpose?
Yes.
They may not even know that utilization of that space in their house for a PG purpose
Yes.
is a commercial activity.
Otherwise, my lord, it is covered under 126, my lord. The
126, I'm very sorry.
anyway,
to say,
my lord,
not one step has been followed.
No.
will
And below,
subsequent to the inspection report, my lord, the provisional assessment bill has been issued.
Okay, you get your instructions. If you,
My lords will direct that with the entire exercise be carried out de novo, my lords.
de novo.
De novo, as far as the 126 proceedings are concerned, the inspection report will stand, my lords.
So I think I'll stay this for some time.
yes, the
Let her get
inspection
some
report
relief.
cannot stand because
You get your
The
you get your instructions.
my
In
lords,
the meantime, we are going to
these
stay.
are my instructions, my lords.
No,
Leave it to my
You
lord.
get it in writing.
Otherwise,
Place it.
this connection.
This
notice
lady,
is
the
there.
moment I do that, tomorrow again they'll be
And against their own
61,000.
policy below tariff.
My
And they have
the-
increased to 1,54,000 or
My lords,
24,000.
where is that increase, Mr.
That is at page 37, I think.
37 to disconnection.
35 minutes. Press bill is at page 36 minutes.
Mr.
36.
P.K. Goswami, Learned Senior Counsel, assisted by Mr.
124,005.
A.P. Bora, Learned Counsel for the petitioner. Thirty-six bill is dated.
Bill is not. The bill date is, bill number is there, period is there, but
Mr. Chaudhary, what is the date of this bill?
Yes, I cannot, it's not legible, my lords, in
I
my
also
copy.
tried to find out. I don't think it is there. First bill is at page 25, this is 36. This has gone up to one lakh.
No, they cancelled the earlier one and they have issued a fresh one.
No procedure was followed.
Okay, fine.
And everything without
Mr. P.K. Goswami, first, the petitioner in the present petition is the wife of late Nityananda Soikya, who had a electricity connection bearing consumer ID number 0171234 site 01135 of from the Assam Power Distribution Company Limited. Also, the petitioner projects that she, being a senior citizen and not having a source of income, had provided shelter to 4 girls as paying guests just to provide for her needs. It is projected that on 7/10/2025, the employees of the APDCA had come to the residence of the petitioner and had forcefully entered therein without, however, disclosing the purpose for such visit. The petitioner subsequently.
These are not even authorized persons. The section 126 requires it to be authorized person.
Subsequently, the petitioner could come to learn that the said personnel of the APDCL had come for an inspection. Further inquiry also revealed that the said personnel were not authorized to carry out the said inspection. Also, in terms of the said inspection, the petition was issued with a preliminary, it's called provisional assessment bill.
That's page 25.
For an amount of rupees
61,000.
61,629.
629. 7/10/25.
Also, the petitioner submitted a representation against the said illegal bill as submitted against the said bill as submitted as furnished to her, holding the same to be illegal and in violation of the and to have been so issued in violation of the procedure laid down in this connection under the provisions of section 126 of the Electricity Act 2003. Also, thereafter it is seen that the matter was processed. Further processed. The petitioner being aggrieved by the actions taken in the matter by the respondent authorities had approached this court by way of instituting a writ petition being WPC number 1958/2026. A coordinate bench of this court, noticing the submissions made by the Learned Standing Council APDCL that the provisional bill as issued to the petitioner and the accompanying notices thereto, including the order passed, was they decided to be cancelled, proceeded wide order dated 8/4/2026 to dispose of the said petition. Granting liberty to the petitioner to assail the inspection report dated 7/10/2025. Also, the respondent authorities thereafter wide an order dated 7/4/2026 by cancelling the earlier provisional assessment bill. Now proceeded to issue a fresh assessment bill purportedly under the provisions of section 126 of the Electricity Act, and now demanded an amount of rupees
1,24,000. 5010.
501 from the petitioner for the malpractice as detected in using the electricity connection other than for the category it was so sanctioned. Mr. P.K. Goswami, Learned Senior Counsel for the petitioner, has submitted that even after the passing of the even after the respondents had cancelled the earlier provisional assessment bill holding the same to have not been so assessment bill, while issuing the fresh assessment bill, also the procedure under the provisions of section 126 of the Electricity Act was not followed.
They relied on the same report of 7/10/25.
Fine. Mr. Goswami has further submitted that the petitioner was not given the due opportunity as mandated in the provisions of section 126 to assail the inspection report as well as the provisional assessment made thereon with regard to the malpractice, with regard to the compensation payable by her pertaining to the malpractice detected at her
Unauthorized usage.
premises, at her premises with regard to the usage of the electricity connection for a category other than the category it was so sanctioned. Mr. B. Chaudhary, Learned Counsel for the petitioner, has fairly submitted that perusing the materials brought on record, it is seen that the procedure as mandated under the provisions of Section 126 of the Electricity Act 2003 was not scrupulously followed prior to issuance of the fresh assessment bill vide the order dated 7/4/2026. However, he submits that he would receive his complete instructions in the matter and apprise this court of the same on the next date of listing. In view of the above, in view of the submissions made by the Learned Counsel for the parties, this court is of the considered view that the validity of the assessment made, including the validity of the inspection report dated 7/10/2025 would be required to be examined by this court. Such examination would be permissible after the respondents have brought on record their response brought on record their stand by way of filing an affidavit. So accordingly, till the next returnable date, the impugned office order dated 7/4/2026 issued by the subdivisional engineer, Zoo Road Electric Subdivision, APDCL (LAR) over shall remain stay.
And the Milord page 37 notice of disconnection should be.
But disconnection, the connection has.
Further,
No.
further it is provided that the order dated 7/4/2026 shall, having been kept in abeyance, having been stayed by this court, the respondents for the said issue shall not proceed to disconnect the electricity connection granted to the petitioner's premises. However, the petitioner shall pay the normal dues as assessed by the APDCL authorities from time to time.
On 17th, my lords, I'll file my.
How many? 4 weeks are returnable after.
My lords, otherwise, my lords, is challenge, respectfully, my lords. Challenge to an inspection report as held by the Honorable Division Bench is not maintainable under.
We are not saying that. We are only with regard to that final
Question
bill.
of jurisdiction, unless otherwise also, my lords.
You
cannot be-
raise that, we will
Yes,
vacate.
my lords, on 17th, my lords, or 24th for that.
It will be
What is the
immediately after the
urgency? I am
vacations. It
surprised.
will be on 15/7.
15th.
Actually, to list this matter again on 15/7/20. That much compensation we are giving to the lady for the trouble she faced. You come up, we'll vacate it, no problem.
My lords.
Lovely.
Notice, issue notice. तो वो करने ही appear करो. Item number?
We have received the instructions, Lord. As Dutta was supposed to place the same.
Huh?
As Dutta was supposed to place the instructions. The instructions are with him, Lordship. So
Where is he?
he is for the personal inconvenience. He is not there, Lordship.
Oh.
At second half, he will be there.
Mr. Das, Mr. Dotto has some personal inconvenience in the first half. We'll have it at 2 p.m. Sharp.
Please, my lord.
2:15.
Please, my lord.
2:15. You can come by 2:15.
Please, my lord. I'm so obliged.
All that.
Mr. Smith, you are appearing for?
Respond number 124, my lord.
Huh?
124, my lord.
1 to 4.
My lord.
Have you completed your instructions in the matter?
But as far as this case goes, my lord, the petition has to raise the issue of maintainability, my lord.
Ah.
That.
You raise that, we will consider.
My lord.
Yes, what is that submission of yours, maintainability?
And if your lordship.
There is no interim order prayed for.
No, my lord. Anyway, when it's the petition, my lord, if your lordship may peruse the section 75 of the ASI Act, my lord.
Who is appearing for the petition?
My lord, I think it's on.
Petition in person, my lord. Greece Agrawal.
Section?
75, my lord.
Of the Act.
My lord, yes, at page 50, if your lordship. Well, the matters to be decided by employees insurance court. If any questions or dispute arises as to whether any person is an employee within the meaning of, or whether he is liable to pay the employee's contribution, the rate of wages or average daily wages of an employee for the.
Yes, Mr. Agarwal, why you should not be instituting this proceeding before the employees insurance court?
My lord, my lord, basically the impugn order is illegal. I have not received any summon notice from them.
Okay, fine, but that order you can always challenge on that ground before the insurance company, before insurance court.
I need to receive all the documents before filing the application.
This is not an RTI. I'm not an SPIO.
No, sir.
PIO.
No, sir.
Of the insurance company.
No, sir.
Then?
They already.
But Mr. G. Agarwal, learned counsel for learned petitioner in person, appearing, learned petitioner in person. Also heard Mr. M. Smith, learned standing counsel, employees state insurance corporation, appearing for the respondent's number, employees state insurance corporation. Issue notice, returnable 4 weeks.
My lord, even when I have an objection of issuing notice, my lord, because my lord, if my lordship may allow, the coordinate benches of this these are some of it, my lord, very recent judgment. It has been held that these are not maintainable, my lord. There are several orders, my lord. Even if the lordship may come to WPC 4139, my lord, 2014. Detailed assessment has been given to these cases, but these are not maintainable. And most of the cases are dismissed at the very threshold, my lord.
Okay. But Mr. G. Agarwal, so-and-so, and Mr. M. Smith, so-and-so. Mr. Smith, at the outset, has raised a plea with regard to maintainability of the present petition before this court in view of the provisions of Section 75 of the Employee State Insurance Act 1948. Yes, what do you have to say on that, Mr. Agarwal?
My lord, basically, I have not received any kind of summon.
I'm
The
sorry,
natural justice
without proceeding here, that you go and tell before the insurance court.
I haven't received any kind. There is natural justice
I know that
violation.
you have got a final order now.
Yeah, the revocation
Got a
of
final order.
yeah.
Go before with that before the tribunal and say this has been given, but the other part which has to be given has not to be given. So this is bad. The tribunal will adjudicate.
My lord, my question is that I'm not denying any statutory liability of my. The order has been passed merely on the registration of code of the ASI. There was no employee at the Tinsukia office. They have assumed that there was an employee and they have charged as per assumption.
Okay, fine. Whatever it is, this court, coordinate benches of this court has also held that such proceedings are not maintainable. I'm bound by that. You want some time to apprise this court or examine this?
I need some time.
Okay. Post with the said submission of Mr. Smith, the petitioner in person prays that he be granted further 2 weeks' time. 2 weeks' time to make his submissions with regard to the plea of maintainability of the present petition taken by the learned standing counsel ESIC. Registry to list this matter again on accordingly. Registry to list this matter again on 17/6.
May I lord please can make a submission?
17/6.
I'd like to make a submission. I may be allowed to submit some application for the revocation of order passed by ESI.
Okay, fine. Whatever you want to do, you can do it.
Okay.
Give it on 17/6.
Okay, thank you.
You take back this corpus.
Thank you.
Possibly timing.
Yes.
This is a partner matter also.
Yes.
This interlocutor application has been filed for
for the timing. Council were responding.
Respond.
petition.
PR Sharma is going for a medical emergency, Lordship.
He's coming.
He'll be coming here, Lordship.
He'll be coming.
Time for timing.
Time.
Obviously.
So according to you, salary of June has been paid.
Paid also.
And it was deposited in his account, but he did not disclose that.
Also.
With regard to February,
February.
you say that he had not worked for 100 days.
100
hours.
100 hours.
So he'll not be entitled to any salary.
So that is the circular lordship, in-house circular of the college law. That is followed by.
That is illegal. So to the extent he has worked, that much proportion that you pay him. Statement will dispose of the matter.
Obvious.
And if you want to take some instruction, have that and come back. We'll have it at 2.
Obvious.
Or will I be blocking your lunch at 2? Yes, madam.
Matter relates to non-payment of balance remuneration amount of rupees 1,42,500 Lordship by the respondent authority. Although the said project was completed long ago, Lordship.
May I please your Lordship? Lordship, I am here on behalf of Standing Council of Animal Husbandry and Veterinary Department. Lordship, we have already filed our affidavit, but Standing Council is not well. So Lordship kindly allow us.
Fine. When?
Yes, they have filed the affidavit.
We have filed. Yesterday we have filed.
Oh. The learned counsel for the respondent submit that an affidavit on behalf of Miss submission is made on behalf of Miss M. Katoki, learned Standing Council, Animal Husbandry and Veterinary Department, that an affidavit on behalf of the respondents represented by her has been filed on 2/6/2026. Registered to list this matter again on 9/6/2026 along with the said affidavit, right?
One second.
And madam, don't be so weak in making submission. Make your submissions boldly. That is your area. Nobody is going to come there. Mannequin. That inquiry proceeding was supposed to be brought here.
Come, in this case, M. Bota says you will be.
We'll take it up after some time. Mr. Secretary is also. If you have that record, just go through one thing. Just find out one thing there. The statement of the delinquent. Although I don't find that to be factored in any way, but just go through it. It's there, marked. It's marked.
No, sir. I'll verify it, sir.
You just verify it. He has, from the inquiry report, I find that he has admitted to everything. If that be the position, the criminal case will not come in. Just confirm that. Mr. Das, what are you waiting for?
I tell 35.
The respondents are here.
Yes.
Who is appearing for the respondent? Kindly ask your counsel to get the response. Just get it. We'll have it. We don't like seniors waiting like this. I said seniors, not elderly.
24 today morning, we have received the affidavit, signed affidavit copy. We will file it closely. License was cancelled, Lordship. It is there.
License was cancelled, not cancelled.
Cancelled.
When?
It is on 22 itself cancelled, Lordship.
Oh, that is not on record?
Lordship.
That is not communicated.
Not communicated to you. Oh.
It was filed in 2020, man.
Oh.
We will file affidavit. We have received the copy laws.
Here the only suspension is there.
Yes, they have come
And in
against
the
the
suspension order, bottom part,
Lordship.
direction that why we will not cancel. And he submitted his reply.
After that, Lordship, the matter is after 2020, Lordship, probably 25 matter was listed, Lordship.
25, then 26 before me.
It is nice sleeping, Lordship, about the last 5 days,
Mr.
Lordship.
K. Gogoi, Learned Counsel for the Learned Additional Senior Government Advocate appearing for the respondents has submitted that the instructions in the matter has been received.
Lordship, we
and
have received a duly signed affidavit copy.
Submits that an affidavit in the matter would be filed by Friday.
Lordship.
So, Mr. Gogoi has further submitted that from the affidavit, it would be revealed that the license of the petitioner was cancelled way back in the year 2022 itself. 22.
20 and 3/6/2022
Was cancelled on 3/6/2022. Also, registry to list this matter again on 18. Not like it, 15/6/2026, along with the affidavit filed by the respondents.
Right. That's
Along with the affidavit that would now be filed by the respondents.
acknowledgement.
My pleasure, Lordship.
Lordship,
Madam, everything we don't want your assistance. You just have a seat. If you require it, we'll tell you.
Lordship,
Yes, Mr. Medi.
yes, Lordship, this particular matter pertains to 2022 only now. Only 2 dates have gone past. On the last occasion, it was a year back.
Oh, we will redress your grievance. That
So-
this is pending and not listed
Yes,
today
so
itself.
basically
Now tell me,
yeah.
what is your case?
Yeah, my case is that I was basically I had opted for this particular advertisement against the advertisement which was there for the post of constable this one general duty and I had applied it and when I had applied it with all my due documents and everything was correct. Then I was allowed to appear in the physical efficiency test. Then I was also allowed to appear in the detailed medical examination also. So in the DAME, I was found fit, and finally, I was given a final merit list mark sheet where I had scored 45.63.
Above the cutoff.
Yes, above the cutoff. So that was my case at that point of time. Now the respondent authority was supposed to take some instructions.
Okay, fine.
Yes.
Forget the instructions. It's not come from 23, 4 years.
Yes.
Now let us try to do it. What is your domicile?
Yes, now what has happened is that when I had opted for the online application, I had given the state of Arunachal Pradesh and the district as Papumpare. And in my address, it was Karbi Anglong. So now, basically, I was there when I had applied at that point of time.
You are in neither in Arunachal nor in Assam.
Yes.
Karbi Anglong.
Yes.
You are in some other place.
Yes.
Do you want to know which place you are? You are in UP. You have passed your matriculation exam from UP.
My lord.
Both this, there is a clear-cut confusion, disputed questions, repetition dismissed.
My lord, basically the way they had corresponded.
No, it's not their problem. It's your problem.
My lord.
In your application form, come to page 46.
My lord.
Open eyes, you have said Arunachal and Papumpare.
My lord.
Right?
My lord.
In your writ petition, you have not even ventured to explain that.
My lord.
Have you explained this position?
No, we have not explained this position.
One.
Yes, number one.
Now come to the top portion, left-hand side, just above 13, 10, matriculation.
My lord.
Board of High School and Intermediate Education, Uttar Pradesh.
Yes, ma'am.
So, one leg is in, what do you call that, Arunachal. Another leg is in Karbi Anglong, but your hands are in
Uttar Pradesh. My lord, just considering the fact that I had also submitted the affidavits.
Candidates will be considered, page 23, clause 3.
My lord. My lord. Candidates will be considered.
Must be the state indicated by the candidates in their online application form, failing which their candidate will be cancelled forthwith. Now, this apparent error, you have not even explained in your petition.
My lord.
I think we should give it a closure. But Madam, anything more to say? Heard Mr. W.R. Medi, Learned Counsel for the petitioner. Take your seats. Also heard Mr. Chakraborty is here.
Yes, Lordship.
P. Chakraborty, Learned CGC, appearing for the respondents. The petitioner in the present writ petition has raised a grievance with regard to non-consideration of his case for appointment against the post of Constable General Duty, for which Constable General Duty, against which post he contends that he had scored more than the cutoff marks in pursuance to the recruitment exercise carried out in the matter. The respondent authorities had issued a notice dated, had published a notice in the employment news dated 21/7/2018, inviting applications from eligible candidates for recruitment to the post of constable, bracketed general duty in Central Armed Police Forces, bracket CAPF 4S, MIA and SSF, and rifleman, bracketed GD, in Assam Rifles, bracket AR, examination 2018. The petitioner submitted his application in pursuance to the said advertisement notice, and in his application, as was mandated, the petitioner had disclosed his state of domicile to be Arunachal Pradesh and the district of domicile to be Papum Pare. The petitioner, as projected in the petition, had thereafter participated in the selection process and completed all the stages thereof. Also, the petitioner was thereafter, on the marks of the said recruitment exercise being received by the petitioner, it was found that he had scored more than that was so scored by the last candidate recruited against the category for which the petitioner had submitted his application. That is to say that the petitioner had scored more marks than the cutoff marks. However, the petitioner not having been issued with an order of appointment, he had approached the respondent authorities, and it is projected in the petition that the respondent authorities had contended that the dossier of the petitioner was under suspected category, and his dossier was returned to the recruitment branch frontier headquarters. Mr. W.R. Medhi, Learned Counsel for the petitioner, by reiterating the facts noticed herein above, had submitted that the petitioner, although in his application form had disclosed his state of domicile to be Arunachal Pradesh and the district of domicile, state of domicile to be apostrophe, and the district of domicile to be Papum Pare, the petitioner during the medical examination and the document verification carried out.
Yes, he had been allowed to appear in the detailed medical examination.
Carried out.
Lordship,
had produced documents envisaging his domicile in the state of Assam, that is, and in the district of Karbi Anglong.
Yes.
Also, he has further submitted that the respondents, having permitted the petitioner to appear till the last stage of the selection process, even after having noticed the variance in the state of domicile as projected by the petitioner in his application form and in the documents as furnished during his medical examination, the respondent authorities had not issued any order towards cancelling the selection of the petitioner herein. Accordingly, Mr. Medi submits that the direction is required to be issued to the respondent authorities to consider the case of the petitioner for appointment against a vacant against the vacant against the post so advertised by the notice dated 21/7/2018, considering the merit position obtained by the petitioner in the selection process. Ms. A. Sharma, learned counsel appearing on behalf of Mr. B. Chakraborty, has submitted that from the materials brought on record in the present petition, it is revealed that there is an apparent variance in the state of domicile of the declared by the petitioner. She submits that although in the application form, the state of domicile was declared as Arunachal Pradesh, the documents furnished by the petitioner during the selection process reveal that he has projected his state of domicile to be that of that's domicile in the state of Assam, more particularly in the district of Karbi Anglong. Accordingly, she submits that apparent discrepancy having occasion with regard to the state of domicile of the declaration of state of domicile of the petitioner, in terms of the provisions of clause 4C, bracketed 3 of the conditions set out in the advertisement, the non-consideration of the case of the petition for his recruitment to any of the forces involved is not erroneous. I've heard the learned counsel for the parties and peruse the materials available on record. The facts noticed herein above are not in dispute. So, the advertisement dated, the notice dated 21/7/2018 was so issued along with the stipulation therein, along with stipulations pertaining to the process of certification and form of certificates under clause 4 bracketed C. Clause 4 bracketed C bracketed Roman 3 small being relevant is extracted here in below. Page 23, A Patham to he 4C to C, A to A multi, page 22, R episode 23, B to B. A perusal of the provisions of clause 4C, Roman 3 small, would go to reveal that the candidates in the selection process are to be considered for recruitment against their respective state / union territory on production of valid domicile / permanent residence certificate bracketed PRC order issued by the competent authority so authorized by the concerned state / UT to prove their domiciliary status at the time of document verification. Also, the said provision also mandates that the domicile / PRC certificate must be of the state / union territory indicated by the candidates in their online application form, failing which their candidature will be cancelled forthwith. The petitioner in his application form, which has been brought on record as annexure 2 to the petition, had declared his state of domicile to be Arunachal Pradesh and the district of domicile to be Papum Pare. However, during the document verification, stage of the selection process, the petitioner has projected that he had produced documents envisaging his domicile status to be in the state of Assam and more particularly in the district of Karbi Anglong. Accordingly, apparent variance has occasioned in the declaration of the domicile status of the petitioner in his application form and at the stage of document verification. Accordingly, in view of the provisions of FUSA, the petitioner not having brought on record any document envisaging, having not produced before the respondent authorities at the stage of document verification, documents issued by a competent authority within the state of Arunachal Pradesh declaring his domicile status in the said state, applying the provisions of section 4 bracketed C bracketed Roman 3 of the conditions of the advertisement, the candidature of the petitioner is required to be cancelled without any further reference. This court on a examination of the this court further on a further examination of the application form of the petitioner has found that the petitioner had appeared for his had completed his class 10 studies and acquired this certificate from the Board of High School and Intermediate Education, Uttar Pradesh. The said position would also mandate that the petitioner has a domicile in the state of Uttar Pradesh. However, in the writ petition, there is no clarification set out by the petitioner with regard to the said variances apparent variances with regard to his claim of a domiciliary status in a particular state. Three states have now been projected to be the petitioner has projected himself to be domicile of 3 states, the said position apparently is in clear violation of the provisions of clause 4 bracketed 2 4 bracketed C bracketed Roman 3 of the conditions of the advertisement of the eligibility criteria set out in the advertisement, and accordingly the non-consideration of the case of the petitioner, although he may have secured more marks than the cutoff marks in the recruitment exercise, in the considered view of this court, is not erroneous. So, in view of the above discussion, the present writ petition is held to be devoid of any merit, and accordingly the same stands discussion. Next time.
Yes.
Yes, Mr. Rama.
There are 4 petitioners, my lord. They have been appointed on my lord 17/1/1995, my lord.
So no regularization?
No regularization, my lord. I am one prayer, my lord. There's an order, my lord. Petition number 4545/2022, my lord. If that order is passed, my lord, similarly situated person, my lord.
Heard Mr. SSS Roman, Learned Counsel for the petitioner. Also heard Ms. Deborah Learned, Standing Counsel, Health and Family Welfare Department. Mr. SSS Roman at the outset has submitted that the prayer made in the present writ petition for regularization of the services of the petitioners is not pressed, in as much as the petitioners are all post 1493 appointees. Ms. Bora, on the other hand, has submitted that, however, Mr. S.S. Rama praised that the prayer of the petitioner for being authorized a minimum of the scale of pay of the comparable post with regard to a comparable post in the regular cadre be considered by this court. Ms. D. Bora, Learned Counsel for the Mr. D. Bora, Ms. D. Bora, Learned Standing Counsel, Health and Family Welfare Department, submits that the petitioners were not appointed by an authority under the Health and Family Welfare Department. The appointment of the petitioners were so affected by the
Hospital Management Committee.
Hospital Management Society of the concerned hospital wherein the petitioners were working. It is submitted that the said Hospital Management Committee Society is not a society. It is not a governmental agency. Is not as government. Is not a government. By a hospital society. Also, accordingly, she submits that the direction, if any, issued by this court for payment of minimum wages to the minimum scale of pay to the petitioner ought to be passed only to the concerned Hospital Management Society and not to the state respondents. I have heard the learned counsel for the parties and also perused the materials brought on record. The petitioners in the in their the petitioners having already petitioners being the alternative prayer of the petitioners for the authorized the minimum scale of pay of a comparable post in the regular cadre is being considered. The petitioners in the writ petition, in the pleadings in the writ petition, and more particularly in the affidavit in reply file, have projected that they were their initial appointment was so affected by the concern by the jurisdictional hospital management committees. Also, the petitioners have further projected that they have completed more than 10 years of service. The prayer of the petitioner is based on the directions passed by this court in writ appeal number 45/2014, quite ordered it passed by this court by a division bench of this court in the case of State of Assam versus Upen Das, order dated 8/6/2017, in WA number 45 of 2014. The said decision in the case of Upen Das, however, has since been set aside by a division by the Honorable Supreme Court. In the case of Sukendo Bhattaji and others versus State of Assam and others, order 2026 INSC 523. Also, accordingly, the directions of passed by the division bench of this court in the case of Upen Das cannot be directed to considered to be applied in respect of the petitioners here. Also, the petitioners having projected that they are still continuing to render their services, this court directs that the petitioner, it would be open for the petitioners to approach the respective hospital management committee and pray for enhancement of their wages at par with the enhancement of their wages also. For grant of minimum of this scale of pay attached to comparable post in the regular cadre. In the event of any such application being filed by the petitioners, the hospital management committee shall consider the same and dispose of the same with by way of passing a speaking order. Such speaking order be passed within a period of 3 months from the date of receipt of a from the petitioners here. All right.
It's a very old matter pertaining to 1987, the additional increment which was, he claimed that it was given was not granted ultimately. So we are finding it difficult to locate the record, my lord. So after,
Okay,
after
we'll
vacation.
go by non-trespass. We'll go by that. Because those notices were issued in 22.
22, my lord, this for the first time it has been listed, my lord.
What is there? But you had the, FCI had the notice from 2022.
Yeah, my lord, give me 3 weeks time, my lord. Actually, we have drafted one affidavit in opposition draft.
This case is simple. In terms of 1989, as AG 3, he having completed 8 years, 16/11/85, he gets 1 increment. Thereafter, in 86, he is
Well,
promoted.
that facts has to be verified, my lord. That
Who
he
did
retired
they-
from
did they- did they
2013.
stop you?
No, my lord, the 2013 he has retired and
This
he has
man
come
is
before this.
retired in 2013.
He has come before this honorable court only in the year 2022, my lord. After a long 9 years,
Oh,
my
you
lord.
mean to say that we'll have to wait for 9 years to maintain that and then hear you?
Now, kindly give me, your lordship, 3 weeks time, my lord. 3 weeks, my lord. We have a partly parawise comment, my lord. Let me file one affidavit, my lord. In
Okay,
19
Mr. Garodia is also not interested.
Yes,
Matter
my-
is
he,
there from
he was
Lord
willing
Chitu.
to
He has
accommodate,
never
he was
tried
willing to
get it
accommodate
listed.
me till vacation, my lord.
Okay. Mr. BK Singh, Learned Counsel for Learned Standing Counsel, FCI submits that the matter has been listed today for the first time after the notices were issued by this court on 23/11/2020. Accordingly, he prays that he be granted time till 13/7/2026, 14/7/2026 to file an affidavit in the matter. Mr. P.K. Garodia, Learned Counsel for the petitioner, does not object. Except the Learned Counsel for the respondents. Accordingly, it is directed that the FCI authorities shall invariably file their affidavit on or before 14/7/2026. No further adjournment shall be granted in the matter for the said purpose. Registered to list this matter again on 27/2026.
Much obliged, ma'am.
This is regarding non-release of the COVID state, madam. Till date, nobody has filed the affidavit.
29 lordship, probably after a long time, it was our instruction received 23 itself, lordship. Probably matter was not listed, that's why not filed. We'll file affidavit, lordship.
Mr. Bora, when did you get COVID? In the office or in the hospital?
No, he is working as a accountant of the police. When during the COVID, he is maintaining the accounts of the vehicle.
I know that.
And that during that period,
No,
the COVID.
I know that. Whether you got this COVID in the hospital or in the office, because you seem to be a chronic kidney patient.
That is the view that there is kidney problem always there.
Now, where is your material to show? Where is your contention in the writ petition to show that till he was affiliated with COVID, he did not have any such problem?
Well, if lordship comes to their own document of the police, my lord, he is being working as a.
I know that. He can work with CKD also. There is no problem. He can continue working. He may be having dialysis also, no problem. But the question is, where is your contention in the writ petition that my husband had no such problem and these are comorbidities which may have occasion after he was inflicted with COVID? Where is that line?
That, my lord, if your lordship transfer page number 31, the police have itself forwarded, my lord.
Police forwarding is nothing.
That along with some other persons, there are 20.
Mr. There is you had got yourself treated in GNRC. There is a report of GNRC. That report does not say that you died because of COVID positive. You died because of comorbidities.
Multiple organ failure, some everything.
Multiple organ failure, just come down. CKD cannot occasion on the day itself.
Even chronic kidney disease is chronic kidney. Our instruction is also deadline, lordship.
Let them
you have just borrowed that and you copy pasted that.
Let them file the affidavit.
Mr. No, their affidavit is not required. You just clarified this aspect.
Then I'll file an affidavit.
Your husband, if you can say that your husband was hale and hearty, he had no problem. He got admitted because of COVID, and thereafter these things develop. If that can be a line of argument taken, then you come within that. Otherwise, we'll have to follow what Mr. Gogoi said.
Then Lord will fix, I will come.
Mr. Bora, learned counsel for the petitioner. Heard Mr. S. Bora, learned counsel for the petitioner. Also heard Mr. K. Gogoi, additional senior government advocate, along with Ms. D. Bora and Mr. S. Dr. D. Bora, learned standing counsel, health and family welfare department, and S. Dr. learned standing counsel, revenue department. Mr. Bora submits that he would file an additional affidavit bringing on record details pertaining to the ailments projected to have been ailments suffered by her husband, along with materials to show that ailments suffered by her husband. Registry to list this matter again after 3 weeks on a date to be fixed. Mr. Bora, you get that, otherwise it will be difficult for us. Retired.
No, Your Honor. I'm not retired yet. Actually, I have to approach this honorable court because of the transfer order 112
Yes,
2022.
That has been stayed 2022.
Yes.
So
We
4
are
years.
interfering. We are setting the cycle.
But in any case, we are also not going for a vacation of the order because we know that medically he is not fit at the moment.
And
You are setting it aside with the further direction that you will not transfer until his date of retirement.
There is a proof. I'd like to.
Mr. Gogoi is saying that is proof for us.
Much obliged, Your Honor.
Mr. Bora, don't touch him.
Moreover, Your Honor, there is.
But in any
service is
case,
not
I
left
don't
too much.
understand why.
Only 2 years, I think. 2 years service is left, I think.
54, 56, 4 years service. This condition, he cannot go anywhere. You keep him within the city of God.
But Lordship may not pass any such strict directions because ultimately the office is taking care of him. That's what I have been told. Because otherwise we would have gone for a vacation of the order which was passed 4 years
Now
ago.
I'm waiting for the kidney transplantation. That is the last status.
But Mr. Good learned counsel, I could learned counsel for the petition. Also heard Mr. S. Borwa, learned standing counsel, Assam Pollution Control Board.
Transplant.
The petitioner has instituted the present writ petition assailing an order dated that Gulaghat thing, na?
Yes. He is presently working in head office. He is transferred to Gulaghat.
An order of transfer dated 1/12/2022,
Yes.
by which the petitioner was transferred and posted to the regional office of the board at Gulaghat. The petitioner in the present petitioner has projected that he was suffering from chronic renal failure, chronic kidney disease, and his kidney and the status of this kidney was deteriorating day by day. So it was under such circumstances, the petitioner. So the petitioner in the year 2021 was assigned assembly election duties. However, the election department authorities, on considering the status of the petitioner, proceeded to relieve him from such duties. The petitioner submits that while the petitioner was under such physical condition, the respondent authorities, while an order dated 11/10/2022, had proceeded to transfer the petition from the headquarters of the board to the what is RLO?
Regional office.
Regional office.
To the regional office at Tespu. Also, being agreed, the petitioner had submitted a representation dated 14/10/2022, and therein had highlighted that in view of his health condition, he may be exempted from such transfer. The respondent authorities thereafter proceeded to modify the earlier transfer, the transfer ordered in the case of the petitioner, while order dated 11/10/2022, by issuance of a order dated 1/12/2022, and the petitioner was now required, and the petitioner was now transferred from the headquarters of the board to its regional office at Gauhati. The petitioner being aggrieved. Thereafter, the respondents had released the petitioner from the post held by him in the headquarters with effect from 1/12/2022. Being aggrieved, the petitioner had instituted the present petition.
Lordship, the petitioner has also approached the board before coming to the court. That representation also may be taken note of. Because ultimately there, apart from his kidney disorder, so he has bought two other reasons. That is, one, his son is studying class 10, mother is 18. So these are the three aspects that he has highlighted.
We are not, we ignore that. We'll not put Mr. Borua into trouble to consider those two.
No, it is the petitioner's application. That's why I was
Forget
referring.
it. We are here. So, the learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner, the condition of the petitioner has deteriorated further, and presently he is awaiting kidney transplantation. Mr. Borua, learned counsel for the respondent board, has submitted that the authorities of the board are sensitive to the health condition of the petitioner, and accordingly, they have not even filed an application for vacation of the interim directions passed in the present matter. Mr. Borua submits that the board authorities shall continue to keep the health condition of the petitioners while assigning duties to him in the organization. Also, I've heard the learned counsel for the parties and perused the materials available on the court. The petitioner in the present petition has assailed the order of his the transfer ordered in his case, while the order dated 1/12/2022, primarily on the ground that he, being suffering from chronic kidney disease, bracketed CKD, is not in a position to move out to a distant place and to stay away from his family members who are staying in Gauhati.
More particularly the medical treatment.
Also, further, the medical treatment required to be received by the petitioner for the disease suffered by him is available in Gauhati and may not be available at the same level at other places in the state. Also, this court, noticing the said submissions, while issuing notice in the present petition on 16/12/2022, had proceeded to stay the order of transfer dated 1/12/2020. The said order continues, said interim order continues to hold the field today. So, when the matter was taken up for hearing today, the learned counsel had produced the medical report of the petitioner, wherein he has been now
waiting for
advised for kidney transplantation and is awaiting such transplantation. Also, in view of the above position and considering the health condition of the petition, this court proceeds to set aside and quash the order dated 1/12/2022. Noticing the health condition of the petitioner, this court further provides that the respondents shall not post the petitioner to any other place other than a posting in the headquarter and or office within the city of Gauhati
Gauhati.
without first appreciating the without first appreciating the health condition of the petitioner.
That is always taken care of, but Lordship, that line may have some repercussion because ultimately that administrative exigency has to be taken care of. Because yes, that line may not be.
Appeal. Without appreciating the health condition of the petitioner and also issuing to the petitioner a notice in this connection. Also, they said directions have been so passed, noticing the materials brought on record pertaining to the health condition of the petitioner. Also, with the above observations and directions, the writ petition stands disposed of.
Highly obliged. Yeah.
In this case, I was supposed to produce the records, Lordship. Today it is not with me, Lordship.
Regarding dismissal, Lordship, of the petitioner, Lordship, from SSB.
Yes, where is the records?
Since it was last listed on 2022, Lordship, it was out of my mind, Lordship, therefore I could not contact it.
Yes. Matter is pending from 22.
Yes, Lordship.
You
Actually,
did not have time even to make a mention for its listing for the last 4 years.
Lordship, actually, Lordship, he had communicated to us, the petitioner had communicated to us that he would change counsel. At the same point of time, Lordship, he's suffering from stage 4 liver cirrhosis, Lordship. So hence, Lordship, communication was not there. Then again, he communicated to us that he's not going to change counsel. This is the sole reason.
Miss R. Devi, learned CGC, submits that she be granted time till man is in a bad ship. We find that this is not proper. He had an explanation for his absence. You did not even factor it. I just want to see how you serve the notices on him. That much only. Nothing more. Other orders will pass.
Unauthorized absence, Lordship.
Unauthorized absence is justified.
And also it has, Lordship,
But you did not give him an opportunity. Now you will have to show that the notices that were there, that you have said to have issued, show cause, inquiry, and the inquiry report. 3 stages. These were served on. Because he does not say anything in the affidavit. Right? So just that much only we want to know. Have you received any notices?
Lordship, no. We have sent through WT messages after the
Okay, where is your statement in the petition that you have not received any notice at any point of time?
Lordship, we have Lordship, Everman number 9 and 10, Lordship, of page 7, Lordship. Lordship, he had filed an RTI, Lordship. After the RTI was filed, eight, 9, and 10, Lordship.
He had also not submitted any application for extension.
Oh, man is dying, kidney. He is gone. Alcoholic.
Alcoholic. But he has, as per his statement, a WT message was sent through.
And you give him free. You give him free. So he had a free thing.
To the government, Lordship. But he personally did not apply for extension.
Para 8, 9, and 10. only that much clarification we want. Heard Mr.
PK Das, Lordship.
PK Das, learned counsel for the petition, also heard Ms. R. Devi. Huh? Ms. Adjournment Bisharishan? Says prayer granted, registry to list this matter when?
On Lordship, 17.
17/6/2026. For further hearing. But if I find that notices were issued and you received, you are in trouble. Yes, madam.
Lordship, on the last occasion, Health and Family Welfare Department taken time to file their affidavit in opposition. Lordship, till that they have not filed their affidavit in opposition.
We are stopping them. You make your submissions. What's this, Mr. Bhuya?
Lordship, actually, this matter is not
Huh?
being done by me, but Miss Deborah. Lordship, she had just gone out, but she has instructed me that there's some instructions.
Oh, this instruction is circulating for the last 2 months. Now you have not proceeded further than this. This is there from last 2 months. It's already noted. It's here.
Lordship, I have informed Miss Deborah. Lordship, she's on her way.
Get her, get her, get her.
Yes, Lordship.
Get her.
Lordship.
And tell Ms. Bora also
Lordship.
that this instruction is there of 29/4/25. Yes, madam. From 29/4/25, only this thing is happening. The records are not come. 29/4/25, same thing. So now, after a year also, it is not taking place. Who is the person responsible?
Some problem is there, Lordship.
That problem we will settle now. Who is this problem maker? Who is not giving the thing?
Joint Director Halagandi said that they have not received the.
Okay, ask your joint director Hailakandi to come online. 2 o'clock. We'll see.
No, Lordship. No, Lordship, it is under.
A man retired in 19. And
Lordship,
you
fix the
admit
matter
that
tomorrow,
you
Lordship,
admit
I will
that
update the
you
instruction.
admit that he is having 273 days. And that much money you can't give him.
Actually, at 2 o'clock, I haven't.
Friday. Ms.
Okay.
Deborah shall learn a standing counsel, Health and Family Welfare Department shall apprise this court as to why the leave encashment benefits of the petitioner has not been released to him, although the petitioners was sanctioned the said benefit wide a communication dated wide communication dated 19/6/2023. The exact reason for the Joint Director Health Services Hailakandi Ms. Bora submits that the Joint Director Director Health Services Hailakandi had instructed her that as the copy of the sanction order has not been received by him and the service book of the petitioner has not been returned after finalization of his pension. The amount required to be paid to the petitioner as his unutilized deep salary as his leave salary.
Otherwise, Lordship may direct.
Not be prepared. The said instruction is also was also produced before this court way back on 29/4/2025. Ms. Bora shall, on the next date of listing, apprise this court the exact reason why this is not, why the petitioner has not been authorized his leave encashment benefit. Although the sanction for the same was accorded, and the authority who is responsible for the same. We will impose interest. Next date, whoever your authority is, they will pay.
I am for respondent number 4 on behalf of Mr. Askin.
Mr. Ikemedi appears on behalf of the respondent number 4. Ms. Bora, please impress upon the authority. I'll give you time till Monday. Guridia. Monday. You take time till Monday.
The petitioner is before your lordship for last 3 years, my lord, only for rechecking our answers, my lord. Class 10, my lord, class matriculation examination. Otherwise, he has secured the highest mark in other subject, but in Assamese subject.
We'll pass the orders. Update Learner Council for the parties at length. Hearing concluded. Registry to list this matter. Tomorrow free date 26/6.
Highly obliged.
For delivery of orders.
For Lordship, I am appearing for the National Scheduled Caste Finance and Development Corporation, Lordship.
Wait, what happened?
Our affidavit is ready, Lordship. I will file it, Lordship.
No, what is your stand?
Our stand is that, Lordship, it is basically the state government. Otherwise, our basic stand is that, Lordship, as per the Lordship sanction letter, it should be conducted to the government, Lordship, that I institute, Lordship. But it was in the private, they have conducted it, Lordship.
Okay.
Center and institute owned by industrial.
Okay, they have conducted.
Even, Lordship, the persons who have given the training, Lordship, no engagement is there, Lordship. Not a single person was engaged, Lordship.
That's a different thing altogether. That engagement is not their heading.
Lordship.
They only have to give the training.
Lordship.
Now, 50% of that amount was given as advance.
Lordship, that part is given by the state
Fine.
authority, Lordship.
So the state has identified that to be a proper body, and it's a training institute.
Lordship.
It's in the city only. Everybody knows it.
Lordship.
It's a old, very old institute.
That, Lordship, beauty parlor, Lordship.
No, it's a training institute come beauty parlor.
Lordship.
I was residing nearby, so I used to see that. So this is an old institute.
Lordship.
The authorities have given them.
Lordship.
There is no allegation that they have not completed that.
But, Lordship, as per the central government scheme, Lordship, we have to follow the national commissioners, follow the central government scheme. The scheme says that, Lordship, the recognized institute under the ITI, Lordship. That is not done.
Fine, that is for the headache of the government.
That part
the government will direct the government to make the pay. Yes, Mr. Das.
Lordship, our affidavit is, Lordship.
Who identified the body?
Lordship.
Mr. Dhar identified. You identified.
My lord,
Pay the amount.
my lord, it is not that.
And then file a civil suit against the central government before the Supreme Court.
Otherwise, Lordship, our affidavit is on the way. They have scanned it and send it to me, Lordship.
Okay, we'll have the affidavit, madam. Mr. K. Gogoi, Learned Counsel for the CGC appearing for the respondent number 4, submits that in pursuance to the directions passed by this court on 29/4/2026, an affidavit on behalf of the said respondent would be filed within a period of 1 week from today. 2 weeks from today. He submits that the affidavit has been prepared and is in the process of vetting. Accordingly, registry to list this matter again after 2 weeks. Mr. Thor R. Dhor, Learned Counsel, appearing for the respondent number 4, shall also receive instructions as to the manner in which the petitioner institution was selected, but the petitioner institution, no? ITC My Fair Lady, was selected for the training, for imparting the training program. Mr. Dhar,
My lord.
get it.
A date may be fixed, my lord, otherwise.
That we have already raised. Lordship, the training was completed in 2010, Lordship. If it was filed on 22.
On 15/7/2026. 15/7. 15/7, you get it. Mr. Dhar, you also get that instruction.
I will get the instruction. And my lord, whether, my lord, after a span of 13 years,
Oh,
16,
this is writ court. We have the power. You are paid 50%. Now the question is whether Gogoi will pay or you will pay.
Probably, Lordship, they have to return it, Lordship, that 50%.
Who?
We have given to the state government.
State, you take it from the state. And state will pay 100%.
my lord, it is, so far I know.
And
my
for
lord,
the time being, go and give him a cup of
it
tea.
is respect number 2, my lord. Respect number 2, that is a craftsman. That is, we were just the mediator, my lord.
I know that. I know that. But he said very boldly that it is you. That's why I've pointed my gun to you.
No,
Now you just come out with that because this list of institutions you cannot get. He will have to give. You show me that he has given them.
That is there in the affidavit.
Oh, fine then. Then we will take care.
Even Lordship, National Commission of Civil Cases, now they have written to the authority to return the money.
Oh, fine. Very good. And money from Mr. Das. Yes. Three weeks. Work has been allotted to one RB associate.
Correct. Now the problem here, what I find.
How was that work allotted, Mr. Das?
I'm sorry.
How was that work allotted to this RB?
There was
For a
e-tender. It's a e-tender.
E-tender?
Yes.
At your risk and cost?
No, that was not done. But no, what has happened thereafter modify the this order. Because what we are on, my lord, there was the interim order passed by this court. When we moved, what was the order? No coercive measure should be taken in so far as the petitioner is concerned. If your lordship looks at 17/3/2025 order, please see the order of 17/3.
17/3/25.
2025. Lordship has seen this.
Okay, I've seen it.
Is there no coercive step be taken against the petitioner? In the meantime, what they have done, if your lordship looks into this order on 21/3/2025, the last occasion, last date, they have produced this letter before the court. We said, to whom you have given? You said that you have given to a particular contractor whom you have given.
They then have declared that it was given to one RB associate.
Yes. Now, I'm troubling your lordship for a moment. The affidavit that has been filed by the state. And if your lordship looks into the affidavit, please look into only one paragraph of the affidavit. Please see that affidavit.
Page?
Page 160, 181. Please see 181. Paragraph 35. See paragraph 35, madam. Further begs to state the e-tender for balance work is already published on 27/12/2024 and that the bids for the same are received up to 12/1/2025. Further letter of acceptance also issued to L1 on 5/3/2025. If that be the case, my lord, while moving the matter or subsequently they should have said before the court. This affidavit has been filed. We received on 25/2025.
No. What is the error here?
No, what I am saying, my lord, you have given fine, but they should have informed to whom it was given at a relevant time.
Okay, fine.
And secondly, whenever the interim order passed by the court, when the interim order was passed by the court.
Interim order is no coercive action against.
Yes, what? Against the petitioner.
Against the petitioner. So they have not taken any coercive action.
No, what they have done, they have given the rest remaining over
But remaining of the work.
But that cancellation of the tender was never stayed.
I'm
by
sorry,
this court.
that was not state. That was not state. Of course, that was not state. What my case was that you knew about the proceeding. At least you could have informed the court that look
Oh,
at this
that
work.
is
You should have, my lord, with
that is the ideal society.
you know,
we have to live in.
2025, when this we wanted to make him a party. Till today, we don't know what is the work, whether he has done the work or not. They are not sure whether the work has been completed or not, or whether he has been done or not. This is, we have received on 21/3/2025 in the court. My lord will kindly see. And the completion
The work
period
is,
is
I
3
think,
months.
practically being completed if it is 3 months.
3 months, that's why they have to inform whether 3
Yes.
months, whether they have been completed or not. Then we'll take a step against them if they could not have completed. There is nothing on record to show that they have completed.
But you had the address of the RB Associate.
I'm sorry.
You had the address of RB
No,
Associate.
what we have received during the course, in the last occasion we received from the court. Now, my lord, my question is that whether this particular work within 3 months has been completed or not. Let them get the instruction.
No, what is your instruction?
My instruction is not been done. That's what I am saying.
Okay.
What is that?
Mr. M. Gogoi, M. Bhuya, Learned Counsel, appearing for the PWD authorities, shall apprise this court on the next date of listing as to the status of the progress of work. Status with regard to the progress of work executed by one Messrs. RB Associates in terms of the notice to proceed with work dated 21/3/2025 issued to it for the balance work remaining after the contract with the petitioner was terminated. Registry to list this matter again on. Can we have it on 10th?
Lordship. Nah. Anytime after that also.
10, 11, 12,
After
15,
56.
15, 15,
Oh no,
5.
after 7 is 15, man. Any day.
Huh?
After 15, any day.
16,
What,
17,
17?
17.
Pardon?
Lordship, may fix it on a hearing day if possible.
18 is 30.
18,
30.
Lordship.
Yes.
18, 6, 2026.
No,
Much obliged.
I'm deeply obliged. And in the statement, affidavit, is because of they have deducted forest royalty. They deducted forest royalty. Now there was an order prior to that in this case that you cannot deduct it. And in the statement which they have filed in affidavit, they say no, from the running bill we have deducted the forest. Already there was a judgment not to deduct.
For
So
the same work.
Same.
For this work.
Yes. And already, no, they now thereafter, in pursuance to the court's order, they have given the money back to us. But while the affidavit was filed, they have mentioned, no, in this particular work, forest royalty has been deducted. See, my lord, there is no application.
There was no tender condition to that effect.
Yeah,
that
no,
you
there was not a part of the contract. And they said it is a part of contract.
Muslim Ali. Oh, this is the Muslim Ali. Forest royalty case.
First royalty, right.
Oh.
Then before a division bench it went. Division. I
So
appeared
that
in
is-
this case. In the single bench I was not there.
Uh,
Division bench. it
I've read
appears.
that. I've read that. I've read.
And thereafter, number of judgments was passed.
Latest is by my Lord Justice Chaudhary.
Yes.
One judgment is.
Yes, I have that
He has
judgment. Yes.
considered everything.
Everything was considered in. Deeply obvious.
Much obliged, Lordship.
Lordship, maybe. My lord, pleadings are complete, my lord.
It is submitted that the pleadings in the matter is complete. Accordingly, registry. Is there an interim direction?
No, there is no interim direction, my lord.
Issue rule returnable 4 weeks. Returnable 4 weeks. Registry to list this matter for hearing in the month of August on a date to be fixed by. Why are you not pressing the writ petition?
No, I'm able to press the writ petition.
I made a prayer. I have accepted it now.
No, I'm just saying that the pleadings are complete, my lord. I just need the performance guarantee money returned, my lord. That's it.
No. Okay, we'll see.
No, please, Lordship. In this matter, also we have filed our affidavit, Lordship.
They have received a copy, lordship, so matter may be fixed.
It is submitted that day by Ms. N. Chaudhary, Learned Counsel, for the Learned Standing Counsel, BTC, that an affidavit on behalf of the respondents represented by her has already been filed on,
Today, lordship.
Today,
has been filed today. Registry to list this matter again on
After 2 weeks, lordship.
17.
18/6/2026, along with the said affidavit.
Well, can it be on 16 then?
16.
16.
Obliged.
Interim order may continue till then.
Interim order passed earlier to continue till the next date of.
Obliged. Please, Your Lordship.
Yes, what have you done with
My
his
lord,
representation?
we have rejected their proposal, my lord. But thing is that there is a huge liability, my lord, on the account of creating unnecessary disputes, my lord, they are not inclined to pay the amount, my lord. The liability is now more than 1 crore, my lord, and out of which only 50 lakhs paying. Even, my lord, no activities are carrying out, my lord.
You have given him a copy?
Yes,
my lord.
Mr. S. Chamaria, Learned
Lord,
Standing Counsel, AIIDC, submits that the proposal as submitted by the petitioner for a full and final settlement of his outstanding dues was considered by the authorities of the AIFDC, AIIDC, AIIDC has been considered by the respondent corporation and the same was a rejected white communication dated 27/5/2026. A copy of the said order, you have received it today?
Yes, my lord, after receipt of that order, my lord, we have already submitted one on 2/6 for clarification of some, my lord.
Mr. A.K. Sharma submits that on receipt of the said or communication dated 27/5/2026, the petitioner has submitted a application seeking clarification of certain aspects as incorporated in the said communication. Be that as it may, the proposal of the petitioner now having been rejected, this court would now be required to consider the issue arising in the present petition on its merits. You can make your submission if you want.
My lord, Lordship, at least, my lord, 2 weeks time may be given to furnish that documents, my lord.
Merits. Accordingly, registry is directed to list this matter again on 18/6/2026 for admission hearings.
Or some interim protection.
My interim, my lord, may not be continued, my lord. That is subject to the disposal of, my lord, their representation that we have disposed of, my lord. But if suppose, my lord, lordship, can you see for a moment, in read petition, page, my lord, 28, the proceeding has already been initiated. Page 20 is the so-called notice, and my lord, the proceeding that we have initiated that contain in, my lord, page eviction part.
Our
Which they put
proposal
on the
not
challenge.
rejected, my lord, not acceptable. They have not rejected our proposal, my
My
lord.
lord, they are even not carrying out any activity. It's a huge property, my lord.
Sharma, you are enjoying a property, but not taking the liability.
My lord, and my lord,
And you have been constantly, you have been delaying the inevitable. Only that much.
My lord, now, my lord, issue is only the, my lord, that amount, my lord. Initially, my lord, they have stated
Lordship,
that.
lordship, you want to protect, my lord, let them pay the amount of, my lord, rest amount, subject to the, my lord, clarification, my lord. They are not inclined to pay any amount, my lord. The interest is, my lord, getting up, my lord, and the rent, even current rent, they are not paying, my lord.
We have
Lordship,
paid,
kindly sit for a
Has he
moment.
paid that 40 lakhs?
yes, my lord.
40 lakhs he had paid.
No doubt, my lord, there is a
Yes,
present liability of, my lord, 1 crore 32 lakhs up to pay.
My lord, originally, my lord, they have stated that amount is 2 crores 21 lakh. Then, my lord, come to 99 lakh. And my lord, now, my lord,
Okay,
it is 82
according
lakh.
to you, Mr.
My
Sharma,
lord.
what is the liability?
My lord, as per my calculation, my lord, it is 50 lakhs something, my lord. If it is in simple interest, my lord. This
That
is the
cannot
issue,
be. That cannot be.
my lord. No, my lord, but some, my lord, some.
What is the rent of the property?
My lord, my lord.
Rent of the property?
A chart is there.
22,000 or something, my lord.
22,000 per month.
Breakup is
From
there.
when it is due?
2007 or something.
7. How many months now?
Calculation was there, my lord.
We'll just do that small calculation.
The Excel sheet is very much clear, my lord. It is applicable to all, my lord, leaseholder, my lord. There is no departure from the, my lord, schedule rate.
Only, my lord, let them direct to my lord to clarify that, that point, my lord.
Okay, your balance is now
132, my lord.
132.
32 up to February
You
2026.
pay another 50 lakhs.
Yes, ma'am.
We'll protect. No, my lord, as per my lord, their calculation up to February, it is 82 lakh 78,000 matra.
So the as per this tally balance, what is the amount, rent amount?
And middle part is there, ma'am. Rent is there. They have to GST.
12,960.
And GST will add it, ma'am.
5200. So total rent is 19,252 minus tax. So this is in areas from 2007 July. So you're simple that rent itself comes to more than 89 lakhs. Rent only. That's and you have now paid 50. Pay another 30 within a week.
I have to take instruction.
Have your instructions are 2 weeks.
Madam.
30 lakhs for the next day till May.
Until
Otherwise, I'm vacating clean bill.
yes, ma'am. Until unless lordship put certain questions, my lord, they will not, my lord, pay any amount, my lord.
30 lakhs today offer.
I have to take instruction.
Adjourned. Next day offer would be 50 lakhs. We'll also have to be careful with the finances of the state. And this is a
government organization.
Organization which is giving money
Now,
to entrepreneurs.
one point on important one, advantage Assam now, lots of proposals are coming pending before us. Now they are occupying the premises, neither they are utilizing nor releasing to Malad.
Well, let him have his instructions. We will provide either for payment,
yes,
or Bakijai and eviction.
If Bakijai we already initiated, okay. The eviction proceeding we have already initiated, but that has been
We'll clear it up. 2 o'clock.
2 o'clock.
2:50. 15 minutes.
Tomorrow, my lord.
Tomorrow. But then it will be 40 lakhs. Okay. Heard Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Mr. S. Chamoria, learned standing counsel AIIDC. Mr. Chamoria submits that the dues receivable from the petitioner as on date is rupees 1 crore.
32 lakhs up to February 2000.
32,
32 lakhs odd amount up to February 2026.
32 lakhs approx till February 2026. Accordingly, he submits that the interim order passed in the present petition be not continued any further. By contrast, Mr. A.K. Sharma has disputed this position, submits that the rates have been not calculated in the manner required. However, it is agreed to by the learned counsel for the parties that at least only going with the areas of rent more than 90 lakhs is due from the petitioner. Mr. Sharma submits that he would receive instructions from the petitioner as to how much deposit would be permissible to be made, can be made by him within a week from today. Can be made. but this I have not reflected, but the minimum is 30 lakhs. Registry to list this matter again on Friday.
My lord,
Mr.
Friday,
Sharma,
time may be kindly 2 p.m. My lord, otherwise may or may not be reached. My lord.
Huh?
Lordship, subject to lordship.
you come and mention, make a mention.
Yeah.
लिख दीजिए। Would be made by him. Also, register to list this matter again on Friday. Date to review. Friday and date to review. Huh?
Under this full and final settlement, madam.
No. For extension of interim order. Only for extension of interim.
Whoever
30
is not a
lakhs.
part of.
Full and final
No,
settlement is between you.
No,
Yes,
no,
my
my
lord.
lord, then in that order was
There's
that,
only waiver
that,
clause,
that
man.
indicated that full and
30 lakhs if you want the matter to be heard.
my lord.
If you don't want the matter to be heard, I will pass an order permitting
Fine.
them to evict you. Finished. That money will, that plot will be used for some other purpose.
Lord, we have received the instructions, my lord.
And why was that statement made in the writ petition, in the affidavit then?
My lord, that it was, my lord, it was
Who is
cancelled.
that authority making that statement?
My
Why
lord-
this false statement was made before this court? Just to mislead this court.
My lord, it was cancelled in 2022, perhaps. My lord.
But this affidavit says that it was cancelled prior to 2013.
No, my lord, if I may, 127, my lord, page number.
That's it.
My lord, those, perhaps, my lord.
Which were cancelled, were advertised for direct. That means after cancellation you had advertised. So,
my lord,
if it was not cancelled, how did you
my
advertise?
lord, there was no intention.
Then how did you, no fine, we get it. How did you advertise if you had not cancelled?
My lord, the issue is, my lord, that these
Forget
posts
issue.
were-
Tell me this.
My lord,
How did you advertise if the post suspension, the post appoint promotions were not cancelled?
my lord,
You had only suspended it.
my lord.
So,
My
so
lord,
we are interfering with
my
that.
lord, however, the
And
post,
all the appointments that were made
my lord, may,
subsequent.
for a moment come to page 154, my lord. This is the this is the order through which the initial,
Mr. Counsel, I understand.
my lord.
You had
this-
only kept it in abeyance.
Yes,
And
my
in 2015, you had recruited fresh people against that.
Yes, my lord.
How can you recruit against a post which is kept in abeyance, not cancelled?
My lord, there might have been some
There is no, it's a big error.
My lord, however, these
The
posts
whole selection after 2026 to 2015 will now, we will not give him anything, but we will interfere with that also.
My lord may pass the appropriate order, my lord.
Okay,
However,
done.
my lord may
Let
consider, my lord.
You want me to pass
No.
the appropriate order? I am passing the
My
appropriate.
lord may kindly consider, my lord, that these posts were backlog posts, my lord.
I got it. When did you cancel those promotions?
My lord, it was done much later in
Then
2022.
how did you make this recruitment?
However, my lord, if my lord, some other persons are now allowed, those will be general candidates who will now would be, if the subsequent recruitment is cancelled, those persons who have already been recruited would be left.
Can't help it. Can't help it. It's your error because that order, there were no posts available. How did you fill it up? You only kept it in abeyance. You had not cancelled it.
That is true, my lord. But my lord.
Mr.
R.B. Goswami, my lord.
R.B. Goswami, Learned Counsel for the petitioner. For the Learned Standing Counsel,
Transport Department.
Inland Water Transport. In pursuance to the order dated 1/6/2026 has placed on record instructions received by him dated 22/6/2026. A perusal of the said instructions would reveal that prior to recruitment being effected in the year 2015, the orders of promotion of the petitioners which were kept in abeyance were not cancelled. In para 6 of the affidavit filed by the respondent number 3, In the additional affidavit filed by the respondent number 3 in the present proceedings, it was erroneously contended that the 22 numbers of appointment in the cadre of Laskar, which was cancelled, were advertised for direct recruitment wide notice dated 6/4/2023. However, there was no cancellation of such promotion effected in respect of 22 persons, including the petitioners herein, prior to issuance of the notice dated 6/4/2023. Accordingly, the recruitment is found to have been made against against posts wherein vacancy was yet to arise. The cancellation of the promotion of the petitioners had occasion only on 25/2022. Accordingly, on the date when the appointments were effected in pursuance to the notice dated 6/4/2023, sometime in the year 2015, there were no vacant posts available. They said instruction would be considered by this court at the time of final disposal of the present litigation. Heard the learned counsel for the parties at length. Hearing concluded, registry to list this matter for do not Hobozano on so and so for 14/7/2026 for delivery of post.
Dated 2023, should be 2013, my lord. Advertisement dated
2013. Advertisement dated, notice dated
6/4/2013.
Mr. Goswami, be very careful when you make your submissions.
Regarding reversion, my lord, two judgments, lordship will consider, my lord. I'll give my lord.
Sir, if I may point out one small point, my lord. In the additional affidavit, it has not been said that the posts were cancelled in
Yes,
2000.
you were cancelled.
My lord,
You
it
have
has been-
said, you have not given the date. Mister, you read the sentence.
Yes, my lord. But it has been stated.
127. That the deponent begs to state that 25, that out of the 25 number of posts, 22 numbers of appointment in the set cadre of so-and-so which were cancelled were advertised for direct recruitment.
My lord.
That means what would be the first impression? That you had cancelled and then given.
It has not been, my lord.
Maybe. That was not the intention, but that is what is coming out.
My lord.
Yeah.
Obliged.
Yes. You want this court to take up the final matter for disposal or the IA for disposal?
As per my lord.
Yes. Okay. Yes, Mr. Soma.
My lord, may kindly have the rejoinder affidavit which I had filed, my lord. My lord would have it from page 45 onwards of the IA, my lord. IA series. The IA, my lord, page 45 onwards at the IA.
45 onwards, yes.
45, yes, sir. My lord, may kindly have page 56, my lord. 57, this is the GB meeting, my lord, of the college, my lord. My lord may have 57, my lord. Here, my lord, there was a discussion, my lord, regarding the post, my lord, regarding the BVOC course, my lord, retail management, my lord. If I may read, my lord.
Yeah, which one do you want?
My lord, that decision, that associate.
Decision, yes, 57.
Yeah.
GB decided to publish.
Yes, my lord. My lord, that was not done, my lord. And my lord, regarding that also, my lord, nowhere, my lord, the principle of the Jagiroda.
When did you join?
My lord, I had joined in 2017, my lord.
When is this decision?
15, my lord.
There were 2 persons appointed before you.
Yes, my lord.
Then?
My lord.
And you received the salary. The interim order is only to the extent of salary.
Yes.
June and February.
Yes, my lord.
February we will take care, but June you suppress.
No, my lord.
Yes, you have suppressed.
My lord, that later on it was paid. We were not.
No, it was paid before you reached this court.
Yes.
You reached this court only on a writ petition to some.
My lord, I had filed the case on.
18/8/2025.
Yes.
The deposit was made sometime in September 2024.
My lord, I have made a statement to that effect. My
You have made a statement that is vague, that cannot be accepted. Your client suppressed fact from this court. A teacher.
My lord, what I have been told is that because the salary.
What you have been told is what you have said before this court, but your client, is he a man with heavy transaction in his account?
Oh my
With a very, then
a
a man who is living hand to mouth will be keeping track of every money which is being debited or credited to his account. So that statement of yours made in the affidavit, in the objection, that he had only after filing of the present writ petition came to know that cannot be accepted. So you suppressed.
Perhaps not suppressed, my lord. Perhaps
You
it
had
was
suppressed.
not a know-how, my lord, regarding the same matter.
Come on. He is a PhD degree holder. This much thing he does not know, we will not impute to him.
My lord, that is the instruction which I have received.
You,
and that-
but I accept that, what you said, but
My lord.
we'll give our reasons.
My lord, apart from that, my lord, may I kindly make one more submission, my lord? Regarding my junior's resignation and his termination, my lord. Mr. Somarjyoti Vaishya's. My lord, there is a body of the college, my lord. Although,
That body we find to be not in any manner involved with the administration of the college.
my lord, may kindly have page 28 of the IA for once, my lord. My lord, the letter which was issued by the body, my lord.
The body is nothing.
My lord,
Once the course is not there, what is the beauty in extending your appointments? You don't have any right. But anything more?
my lord, regarding the funds of the college, with the query which was posed to me on the last occasion, my lord.
Forget it. We have forgotten that. We don't want that.
My lord, I have raised, my lord, I have received certain documents, my lord.
We don't
I have
want to
appended
see.
in the.
Is it on affidavit?
Yes, my lord.
Where?
Yes, lord. My lord, in my affidavit at page 45, my lord, it starts the rejoinder affidavit.
Where
My
is
lord,
the point?
page 69, my lord, the
Clear suppression we find here.
69, my lord, should have annexure 4, my lord. My lord, would kindly have the Jagir, at point number 4, my lord, the Jagir Road College BVOC fund, my lord, 16 lakh 967.
What is this, Mr. Das?
That was utilized lordship long back, lordship.
This is 2017.
Lordship.
Okay.
Thereafter, my lord.
So I have given reply, lord.
Sorry, my lord.
Yes, yes.
I'm sorry.
Yes, Mr. No, so yes.
Thereafter, my lord, at page 70, my lord, next page. My lord, this is one of the CA's report, my lord.
Okay.
Internal-
What do you want? You want regularization?
No, my lord,
No, what is your prayer now? Tell me.
now, my lord, since the department is not there, but my lord, my termination was illegal, my lord.
So you want compensation for that?
My lord.
Go before the civil court. Anything more? And the salary June you have suppressed. February we will take care.
My lord.
Anything more? So you don't want regularization. You want compensation.
My lord, regularization department is not there. Otherwise, I would have sought for my lord.
Lekha. Heard Mr. P.R. Sharma, learned counsel for the petitioner. Also heard Mr. S.K. Das, S. Das, learned standing counsel. Oh. WPC लिखी बड़े. Learned standing counsel, higher education department, appearing for the respondents number 1 and 2. For 3. What's your name? R. Devi, learned counsel, appearing on behalf of respondent number 3, and Mr. R. A. Sheikh, learned counsel, appearing on behalf of respondent number 4. Mr. S. K. Das appears on behalf of respondent number 6, 5, and 7. None has appeared for the respondent number 6. Mr. P.R. Sharma at the outset has submitted that he would not be pressing the prayer of the prayer made in the present writ petition pertaining to the release of the petitioner from the services of the college in as much as the Department of Vocational, what is it called?
BVOC retail management course.
V O Dangor C retail management has since been closed down on account of students not enrolling themselves for the said course. Mr. P.R. Sharma submits that he would limit the present repetition to. However, Mr. Sharma submits that he be granted liberty to approach the approach the civil court of competent jurisdiction, claiming compensation with regard to his arbitrary release from services. Mr. Sharma submits that he would press the prayer made in the. But there is no prayer for release of salaries here.
My lord, it is there perhaps, my lord. My lord may kindly have page number 18, my lord, 1/8 of the writ petition, main writ petition.
Okay.
Interim, my
Submits
lord.
that he would press the prayer for release of his salaries of the petitioner for pending for the month of June 2024 and February 2025. Right? Mr. S.K. Das, learned counsel appearing for the respondent number 5 and 6 has submitted that the salaries for the petition for the month of June 2024 was already authorized to him in the month of September 2024. However, the petitioner, while instituting the present petition, has suppressed the said fact. With regard to the prayer of the petitioner for payment of salaries for the month of February 2025, where is that resolution?
Your Lordship, page 42. Page 42 of my affidavit, additional affidavit, my running page 42, Lordship.
Has submitted that the petitioner during the month of February 2025, having not worked for minimum 100 hours, that is for 20 to 26 working days, or 60 hours for 10 to 16 working days, his salaries have not been released. The petitioner is contented to have worked only for, where is that document, 82 hours?
Page 40, Lordship.
Found to be have worked only for 16 days, and that too for 82.24 hours. Also, accordingly, he submits that the pay of the petitioner for the month of February in terms of the decision of the governing body of the college would not be mandated to be released. Also, considering the submissions made by the petitioner in the present petition, this court provides that the release of the petitioner provides that the petitioner would be at liberty to approach the civil court of competent jurisdiction, claiming compensation with regard to his release after establishing the fact before the said court that the same was illegal. Also, with regard to the prayer made by the petitioner for release of his salaries for the month of June 2024, this court finds from the materials coming on record that the said salary of the petitioner was credited to his account in the month of September 2024. However, the said fact is not found to have been highlighted in the present writ petition. The petitioner in the pleadings brought on record in the connected interlocutory application being I/C number 3395/2025 has projected that it was only after the filing of the connected interlocutory application that he could come to learn of the salary for the month of June 2024 being credited into his account in the month of September 2024. This court has peruse the said contentions made in the petition in the said interlocutory application by the petitioner hearing and finds the same to be not acceptable. The petitioner has not brought on record as to why the messages which were why his account was not being considered, was not being updated. I'm not like cannot be accepted. Also, having drawn the said conclusion, this court finds that the salaries of the petitioner for the month of February 20 has not been released to. The petitioner, the college, response number 5 and 7 have contended that the petitioner not having worked in terms of the norms set out for working hours for contractual teachers engaged in the college by the governing body of the college, he is not entitled to receive any pay for the month of February 2025. This court finds that the petition that set prescription to be clearly arbitrary. The petitioner petitioner on the own showing of the respondents number 5 and 7 had worked in the college for 16 days and 16 days and that too for 82.24 hours. The petitioner having been found to have worked in the college for at least 16 days, he would be entitled to at least half the salary, half the wages as authorized to him for the whole month. Accordingly, the college authorities are directed to compute the wages of the petitioner for 16 days and to release the same to him within a period of 1 month from the date of receipt of the certified copy of this order. Anything more? No, sir. With the above observations and directions, the present petition stands disposed of. Interim directions passed earlier stand vacated. 8. No order.
Obliged.
Yes, what is your instruction?
My lord. My lord.
Yes, where is the required material? Nothing.
My lord.
You have not issued to him any notice for before blacklist.
My lord, as per SOP, my lord, we have issued the termination order, my lord.
Termination order per se will not be a blacklisting order. Both have different intentions. Termination is between you and the person. Blacklisting is between the person and the whole.
Lordship may kindly have the SOP issued by the government of India, my lord. We have followed that only, my lord.
Where?
My lord, I'm reading.
Where?
Page 20 of SOP. Default management provisions, major penalty. In case of violation of norms, sir, severe default in performance, fraud
So,
will be imposed as
Mr.
following.
Doctor,
My lord.
this has to be read here. That notice has to be read. Supreme Court decisions are there. Right till Gorkha. And then there is another one. Ulja.
My lord.
So this is the basic requirement. You give him a notice.
My lord, second
stating your intention.
Point
that
one.
you're going to blacklist him. And the reasons. That's all.
My lord, just one, my lord. Point 1, my lord.
Point 1.
Whenever a project is terminated.
I'm sorry. I will not accept that.
So in that case, lordship may give liberty, my lord, to the department, my lord.
No. We are staying this.
With the liberty, my lord.
No, you file it.
In the meantime, we will recall, my lord. We can recall, my lord.
We'll serve a copy in that case, my lord.
No. It's only
Well,
this
Lordship-
order whether it is legal or valid. It is, why
Lordship
should
is-
I
Lordship
give
is-
you an idea? No,
Lordship is interfering only because we are
I'm
not serving.
interfering. I'm only staying in for the time being. You file your affidavit, you'll see.
But in that case, it will be delayed, my lord. We'll recall and we'll serve a copy, my lord.
Okay, you delay it, can't help it. We are not touching the termination. Okay, Mr. Das, we are staying
Please,
in.
my lord.
But Mr.
Only
Das-
blacklisting, my lord.
Huh?
Only blacklisting part, my lord.
Only blacklisting part. That is that order dated
20th of May, which my lord will find at page 29.
29. Yes, yes, yes. 29, yes. But Mr. N. Das, Learned Counsel for the petitioner, also heard Mr. S. Dr. Learned, Standing Counsel, PNRD Department. The petitioner in the present petition has assailed an order dated 25/2026 by which the petitioner company was blacklisted from participating in any projects or schemes under DDU-GKY, in the state of Assam for all purpose with immediate effect for indefinite period until further order. The details of the blacklisting is also projected therein to be intimated to the Ministry of Rural Development, Government of India and other state missions for information and necessary. The petitioner has challenged the said order of blacklisting order dated 25/2026, blacklisting the petitioner firm or petitioner company on the ground that such blacklisting was so effected without giving to the petitioner an opportunity of hearing. It is projected that no notices preceded the order dated 25/2026. Mr. Dr. on the last occasion was granted time to complete his instructions in the matter. Mr. Dr. has completed his instructions and has made his submissions in the matter. So from the instructions produced by Mr. Dr., this court does not find that any notices were issued to the petitioner intimating the petitioner about the intention of the respondent authorities to blacklist it on account of the default committed by it in the connected contract, which has already been terminated. Also, this court has considered the submissions made by the Learned Counsel for the parties and also perused the materials coming on record. On a perusal of the order dated 25/2026, this court finds that the said order was so issued without there being a prior notice issued to the petitioner intimating him of the intention of the respondent authorities to blacklist the petitioner company along with the reasons for the same. Accordingly, the petitioner is found to have been denied an opportunity to place his case against such blacklisting intended by the respondent authorities. Further, this court finds that the blacklisting has been so effected for an indefinite period, which in the tentative view of this court is also not permissible. So, it is a settled position of law that a person, that a firm, that an entity sought to be blacklisted must be afforded reasonable opportunity by serving upon it a show cause notice, making it aware about the precise case set up against it and the proposed action sought to be taken. So, it is also clear that one cannot be blacklisted for life, and the period of blacklisting is to be proportionate with the nature of offense or nature of breach committed by the entity sought to be blacklisted. This court finds, this court is of the prima facie view that the said basic requirements have not been complied with while issuing the order dated 25/2026. So, accordingly, in view of the above discussion, till the next returnable date, the order dated 25/2026 shall remain stayed. The respondent authorities are further restrained from issuing communications to the Ministry of Rural Development, Government of India, and other state missions about the blacklisting of the petitioner herein. If such communications have been issued, the same be recalled. So, registry to list this matter again. Issue notice korana nahi.
No, my lord.
Ekini likhi ke nahi. Kasan to likha. Issue notice. Mr. As doctor, you are appearing for all?
No, my lord. I am for, my lord, 2, 3, 5.
2, 3, 5. Mr. As Doctor, Learned Standing Council, photo likhichu ebo. Mr. S. Doctor, Learned Standing Council, Panchayat and Rural Development accepts notice on behalf of respondent number 2,
3, and 5.
2, 3, and 5.
1 and 4 Union government, my lord. Central
1 and 4. Mr.
K. Gogoi is maybe.
A. Gogoi, Learned CGC accepts notice on behalf of respondent number 1 and 4.
And 6 notice has to go.
Of no formal notice. Petitioner to take steps for service of notice upon date. 6 by way of raise speed post set within 2 working days from today. Huh? Ekini to hard likhi, tamshet ekini likhibi, ar pisot kahini ko kuch.
Regarding
No,
the
obliged,
prayer,
madam.
Raised it to list this matter again on when? When can you file your affidavit?
3 weeks, man.
As per the convenience of the
Notice
court.
has to be served, man. Or
We'll have it on 14, on a hearing day on 14/7/2020. The respondents to bring on record their stand by way of filing affidavit on or before the next date of listing. 14,
I'm so obliged.
well, regarding the
obliged,
prayer
madam.
number 2, I have objection, my lord, because they are seeking, my lord, relief under Arbitration Act, my lord. But as per the MOU, my lord, there is no such clause, my lord.
My lord, we are not pressing that particular relief at this point in time. That can be placed on record. Because that particular
Prayer
remedy
number
will
2.
lie before the.
Prayer number 2,
Yes,
my
ma'am.
lord.
It is
Pending
at page
disposal,
number
they restrained
24.
from taking any
Well, page
coercive step.
24. Page 24. That is interim, my lord. Lordship is reading interim.
24.
Page 24.
You are not pressing 2.
My lord, that I'll have to press before the section 11 court.
Oh.
Because I have invoked
the
arbitration.
The counsel for the petition at the outset submits that prayer number Roman 2 is not pressed in the present proceedings.
Well, hello.
I'm so obliged. Obliged.
Yes. Records.
Yes, sir.
I have leg marks in that.
Clear admission. Where is that? Petition. None appears for the petitioner even on second call. in terms of the directions, in terms of the undertaking made before this court, the respondents have produced the original of the DP file, departmental proceeding file of the petitioner. So, for the ends of justice, registry is directed to discuss this matter again. Top of the list, for admission on Friday. You keep this, I've done with it. The records produced are returned to Mr. So-and-so Learned Counsel for the Learned Government Advocate. Return. Who provided you? Yes, madam.
Some instruction has been received, my lord.
Have you identified these places where she will install?
Yes, my lord. All are not installed, my lord. Installed.
Yes, madam, you have been asked to approach the district authorities so that the places can be identified.
Yes, yes.
But it seems that you are not going.
But no such communication is there, you know. Just a few minutes back, I came to know from her only. Our last letter was in October 2020.
Okay, now that you have come to know, approach the district authorities of each of the places wherein you have made those supplies. They'll identify and give a letter in writing, take acknowledgement.
Yes.
Rest, we will take care. About the delay and all, we'll take care. But first you get your work completed.
Yes,
Because 10% amount is kept back only because that you have not installed the matter.
yes, sir.
Do it.
And no, my
Or
point
is it that it would
places
be
are not-
below your status to talk to district level officers?
many times, your lordship, I have annexed it many times.
District
In
level
district,
officers.
yes, not district level.
Ah,
This is for the first.
you want to
I have-
talk to the top brass.
Yes,
Maybe
yes.
because you are very top company, naturally. But you got to do a work, you will have to do there. Heard the Learned Counsel for the parties. Miss A.
Bora.
Bora, Learned Standing Counsel NHM, has placed on record the instructions dated 35/20/26 received by her from the Executive Director NHM Assam. A perusal of the said instructions reveals that the petitioner hearing was advised to depute its representatives to the respective districts for installation and commission of the supplied equipment. It is further highlighted that to facilitate the process, the NHM Assam had issued letters to all joint directors of district health societies requesting verification of the supply and installation status claimed by the petitioner. However, it has been highlighted that the petitioner failed to establish effective communication with the concerned district health societies and continued to address reminders to the NHM state headquarters. It is further projected that a communication dated 4/6/2024 was also issued to the petitioner in this connection. Ms. D. Chaudhary, Learned Counsel for the petitioner, has submitted that the said communications in all probability have not been received by the petitioner. However, she submits that she would advise the petitioner to act to approach the district health societies for identification of the sites wherein the supplied items are required to be installed. She submits that she be granted a period of 2 months for the purpose. Ms. Bora shall furnish a copy of the instructions received by her today to Ms. D. Chaudhary for doing the needful. So accordingly, the petitioner is directed to comply to approach the district health societies wherever the supplies have been affected for installation of the supplied items, and the district authorities are directed to cooperate with the petitioner in this connection. So, registry to list this matter again. Five 8/2026. Copy of the communication instructions furnished by Ms. A. Bora is kept on record and marked as X for the purpose of. Ms. Chaudhary, ask them, let them. And if they still have problem with the talking to the district level authorities, file a 2-page affidavit for them. We'll get the NHM to talk to them.
Yes.
Item 68 is an IA mailer filed in this repetition, which is listed in item number 42 mailer. By filing this IA mailer, I want to implement opposite party number 9 to 13 as respondent in the repetition mailer.
Why?
Mailer, the petitioner approached this court for non-payment of subsidy in a scheme which has been initiated by the central government, but I have not made party, the Union of India, in this petition. That's why, my lord, it's important to implement Union of India as a party respondent ballot.
Your first statement.
Yes, madam.
Yes, Mr. Goswami.
Yes, Lordship. Yes.
The present interlocutory application has been instituted by the applicant, who is the writ petitioner in WPC number 1302/2026, praying for permission to implead the opposite party number 9 to 13 as party respondents number 9 to 13 in the connected writ petition, that is WPC number 1302/2026. The Mr. J.K. Goswami, learned counsel, J.K. Goswami, learned additional senior government advocate
Lordship,
appearing
standing
for
counsel,
the
Lordship, standing counsel,
standing counsel veterinary and
Animal Husbandry and Veterinary Department.
who will appear for the government.
Government, Lordship, my learned friend live here.
Hey, Mr. So-and-so. Learned government advocate appearing for respond number 1. Mr. J.K. Goswami, learned standing counsel, veterinary, animal husbandry and veterinary department appearing for respondent number 2. 1 and
2, 4, 5 and 6.
1 and 4 2,
4, 5, 6 and 7, Lordship.
4, 5, 6 and 7. And Mr.
J. Borwa for 8.
J. Borwa for respond number 8. Opposite party number 8. The learned counsel appearing for the opposite parties number 1 to 8 have no objection in this court allowing the prayer of the petitioner made in the applicant made in the present interlocutory application. So, I've heard the learned counsel for the parties and also peruse the materials available on record. On a consideration of the contentions raised in the present interlocutory application, this court is of the considered view that given the nature of the issue arising in for consideration of this court in the connected writ petition, the impleading of the opposite party number 9 to 13 therein would facilitate adjudication of the same. So accordingly, the petitioner is permitted to implead the opposite parties number 9 to 13 in the as respondents number 9 to 13 in the connected writ petition as follows. Page 5A to page 6A. Again, my dear, hold point, my dear. With the above observations and direction, the present present interlocutory application stands disposed of. WPC. In view of the order passed today in bracket C 1828/2026, permitting the petitioner to implead the following authorities as respondents number as respondents number 9 to 13 in the permitting the petitioner to implead as respondents number 9 to 13 the following authorities. IDB taking A to A put semicolon. The petitioner is directed to file an amended cost title within 2 working days from today. On filing of the said amended cost title, petitioner to take steps for service of notice upon the respondent number 1 through the office of the Deputy SGI, Gauhati High Court. Also, steps upon the respondents number 10, 11, 10 and 11 be taken by way of 12 and 13 through the government advocate. Assam. On filing of the part of take steps, petitioner to take steps for service of notice upon respond number opposite party respond number 10 and 11 by way of speed post steps within 2 working days. Registry to list this matter again after 4 weeks. WBC.
My lord, 2 grievances. One I will abandon. Second part, my lord, your lordship can take care of because.
Which one? Which are you abandoning? Which are you keeping?
Abandoning the claim that revenue part. And
because you have already inspected that.
Yes, my document. My lord will kindly come to page 33, my lord.
And what is the second prayer?
Second prayer is to demarcate the bill, my lord. Circle official could not demarcate. If your lordship kindly comes to page 33.
Yes, Mr. Soma.
Yes.
That's a very valid prayer.
No, not on revenue. That we are supporting.
Revenue, we are not even looking at him, but that demarcation, you have your instructions.
No, lordship can dispose it of. Lordship, there is nothing to, even with the consent of my petitioner friend also. Lordship can dispose it of. DC will demarcate it. We are supporting them in that case.
Yes, what does the DC say?
DC has to do it. We have no power to demarcate anything. We have only to give, we are given the lease.
I have not received instruction, my lord. That the action can be passed, my lord. Directing the circle officer to demarcate, my lord.
Yes, just give me some background on that. So
My lord, I applied for the bill and then bill was approved in my favor. Possession was handed over to me. Then after having found some difficulties, my lord, I made applications before the AFDC. These are the problems. Please demarcate the bill. Accordingly, AFDC forwarded the same to circle officer, and circle officer, your lordship will find at page 33. After verification, it was found.
There were 2 bills there.
1 bill, my lord. Why I'm insisting on page 33, your lordship will see at the time of contract, it was declared 70 hectares and physically it was found 25.73. That part I am abandoning, my lord. Now demarcation part, if demarcation is done and the ingress and egress point of the bill coming from Brahmaputra river water is open, I have no problem, my lord. This is my limited prayer, my lord. Well, I do not know how much my bill is now. The total area of the bill. Boundary line, no,
Lordship, what we are doing nowadays, Lordship, in the tender bid, seeing the things we insisted that there is as is where is basis. So they signed it, Lordship. They have given as is where is basis. We are giving the bill.
So you misled him.
Not misled. This part is being upheld by the division bench.
That is that you misled him.
Lordship. So as is where is, because there is all some enforcement is also there in some cases, not in these cases, Lordship. So that part, they used to inspect it beforehand, Lordship.
Heard Mr. H. Das, learned counsel for the petitioner. Also heard Mr. P. Sharma. No, who is there? Head of you. Mr. P. Sharma, learned standing counsel, fishery department, appearing for respond number 1. You are appearing for respond number 1 also?
Yes, 1, 2, 3.
3, 4, 4.
4.
Also heard Mr. Swanson, learned government advocate, appearing for the respond number 5, 6, and 7. The petitioner in the present writ petition had
Instruction to
prayed for.
See, there was an instruction. Due to this instruction, they are abandoning, Lordship.
That is in the record.
To reduce the revenue of Kakorikata Mahal of Madhya district on account of the reduction in the area of the Mahal from 70 hectare to 25.73 hectare.
The bill, it should be bill.
Meal, Kakorikata bill. Bill. Mahal, mean Mahal.
Bill.
The petitioner has also prayed for a direction upon the respondent authorities to demarcate the area of the bill by opening the channel of ingress and egress point of the bill also. Mr. P. Sharma submits that the petitioner, having submitted his tender after inspecting the bill and also considering the current condition of the bill, he cannot be permitted to make any prayer for a reduction in the revenue required to be deposited by him for operating the said mahal. Mr. H. thus learned counsel for the petitioner fairly submit that the petitioner would not be pressing the said prayer in the present writ and would only press the prayer for a demarcation of the bill. Also, in view of the above, accordingly, Mr. Das submits that the present writ petition be disposed of, directing the jurisdictional deputy commissioner to carry out a demarcation of the.
One thing, my lord. Demarcation has already been, inspection has been done for demarcation, my lord. Lordship may peruse the page 32, my lord. Demarcation has not been done only because, my lord, they have not provided the boundary of the bill, my lord. That is the difficulty, my lord. If the FDC provide the details, my lord.
Of the bill area also.
The bill area is with the deputy commissioner. All details in the deputy commissioner. It used to be.
Also.
In the fisheries, it is 6.
Mr. Surya, learned counsel appearing for the learned government advocate submits that the demarcation of the bill area was the process for demarcation of the bill area was initiated. However, the same could not be completed as there was a discrepancy within the claim made with regard to the area of the bill by the petitioner as well as AFDC and the area recorded in the land records with regard to the area of the bill as recorded in the land records. So the said issue need not detain the court further, and this court would direct the the jurisdictional deputy commissioner to carry out the demarcation of the bill by adhering to the area of the bill as reflected in the land records maintained in this connection. So the petitioner as well as the petitioner as well as the authorities of the Assam Fishery Development Corporation Limited shall extend full cooperation to the district administration in the matter so as to ensure early conclusion of the process of demarcation. On the demarcation being effected, appropriate communication in this connection be issued by the district authorities to the AFDC, who in turn shall communicate the same to the petitioner herein. So the said exercise be initiated within a period of 15 days from
Lordship,
the date of receipt
It
of
may not be possible, Lordship. Let it be 2 months, Lordship.
15 days from the date of receipt of a certified copy of this order and completed within a period not later than 2 months thereafter. Also, with the above observations and directions, the present petition stands disposed of.
I am obliged.
Obliged, Lordship.
When Mr. H. Das is there, everything would be possible. There'll be nothing.
Lordship, I thought it will be big argument.
You don't know, Mr. Das. He got what he wanted, Lordship.
It's not like that.
You have not seen him. We have seen him.
Lordship. Obliged, Lordship.
Please, Your Lordship. Well, in this case, for respondent numbers 4, 5, and 6, I was supposed to file my affidavit. It is ready, but I have just been served a copy today. I've been served a copy of this affidavit in reply filed by petitioner. They contain certain allegations regarding this data storage and the system of the IOCL. These need to be answered. If there is no adverse entries against the petitioner, their case stands fortified. If there are entries, then further discipline action may be necessitated.
Okay, do whatever you want to do, but do it fast.
On 16, my lord may have it on 16. I'll be ready with my affidavit.
Mr. N. Borwa, learned counsel, appearing for the respondent number 4, 5, and 6, submits that he would file the affidavit on behalf of the respondents represented by him on or before.
On or before 14. Or 12.
12. We can file reply, my lord.
12. 6/2026. Registry to list this matter again on 16/6/2026.
Obliged.
Reply obliged.
And if he has filed it has not come, give a slip, we'll give it on 16. Yes, Mr. NNB Chaudhary, what are you waiting for?
63 order has been complied with.
For that, see the greatness, you have come.
That's how I come to know.
Payments have been made.
Yes, sir.
PVC payments.
Yes, sir.
You can ask your junior, we'll record your name, you can leave. It's not that we don't like you, but a senior, we don't want to keep waiting.
May I please, Your Lords? What's my drug license has been suspended. Without informing me.
What is the finding of the CFSL?
This
Laboratory?
report, my lord. So it says that basically it was a counterfeit drug.
Okay, counterfeit spurious drug.
Yes.
Uskoscol, Udilif, it's
So-called, it's for liver.
liver.
Yes.
Uroscol is a
Arsocol.
bit price lower than Udilif, 300.
Yes, I
So
think.
people go much for this, and that is being now spurious. It's a serious thing. Now, what happened after the report? Has the criminal prosecution been initiated?
Yes, my lord.
Huh?
Yes.
Then what is left here?
Today I want.
So it's pending.
Go complete it there.
No, my lord. On 7th of January, whenever my drug license was suspended, on that very day, I was arrested also.
Arrested, lordship.
So thereafter, on 9th of February, I was released on bail. But on 19th of January, they issued the suspension order, my lord.
Okay, after that.
No, before that.
Before that.
So during my
Oh, before your arrest.
yes. No, before release, my lord.
Okay.
So it is that page,
It was
20
for
page
non-receipt of
28, my
the
lord.
reply.
Non-receipt of the reply. So how can I?
You have been bailed out now. You have been bailed out.
Yes, I have been bailed out later on 9th of February. But the suspension was made on 19th January. No so cause was issued to me. Whenever I approach on 27th of
7126 itself, Lordship.
So cause has been issued.
Yes.
yes, so
so
cause has
cause
been issued, but it was not served upon me.
Because you were inside.
Just served, but he has
Because
not
on the
replied.
very day itself, I was arrested.
Okay, how did you serve the copy on him? Where is the show cause?
So cause it at page 27, my lord.
When did you receive this?
On 27th of February, whenever I approached the office, my lord.
Final orders have been passed here on this.
Appeal?
Huh?
No, my lord. Nothing.
Appeal was preferred, Lordship. It is under examination. So, Lordship may
So
kindly.
from
give me
March,
some
they have been
time
examining it, my lord.
Whether it is what the decision has been taken.
My
by
pharmacy
government.
has been sealed from January, my lord.
Short date, Lordship.
No, this is only suspension. Where is the show cause? Show cause has not been issued.
So cause is at page 27, my lord.
It's 27,
27.
Lordship. Yes.
Okay.
27, Lordship.
So you submitted a reply to this.
No,
You
No.
have not
because
submitted.
I couldn't. On
No, when you got it on 27/2, you did not submit a reply thereafter also.
thereafter I submitted the reply.
Submitted.
Yes.
What happened to that proceeding?
Nothing.
Ms. D. Bora, Planning Council, Health and Family Welfare Department shall, on the next date of listing, apprise this court as to the steps taken by the respondents after the petitioner had submitted his reply to the show cause notice dated 7/1/2026. Further, Mr. Bora shall also apprise this court about the steps taken by the appellate authority after the petitioner had submitted an appeal against the order of his suspension, invoking the provisions of Rule 66(2) of the Drugs and Cosmetic Rules 1945 against the order of his suspension dated 19/1/2026. Registry to list this matter again on 11/6/2026. 12/6/2026.
My lord,
Oh, you're not here.
my
Madam,
lord,
you'll not be here.
I'll be here, Lordship.
Then it's fine.
On
Get it.
12.
Get it.
my lord, one clarification.
On
It's-
16, Lordship.
It's not exactly a reply of the so cause, but on 27/2/2026, I made a representation stating that my seal may be.
On 16, Lordship.
reply diya bole kuch na kati diya. In pursuance to the show cause notice issue.
Much obliged, my lord. 20.
On 16, Lordship.
16. Okay,
Yes.
16.
Much obliged.
Obliged.
6/2026.
Please, your lordship. Lordship, here, the order of the Honorable Court dated 21/9/2022. But page 15, the relevant portion. Middle paragraph.
Yes. Verification done.
Verification done.
Where is that
It
verification?
Page 22 of the writ petition, my lord. First page 19. This is done by respondent number 6. It is submitted to respondent project director. Then page 19 and 22.
Okay, that change in the
My
site.
lord.
Yes, Mr. Doctor.
Due to
My
their
lord,
mistake.
direction was for commissioner, my lord, not for the district authorities, my lord. The direction from the court, my lord. After the, my lord, verification, it was found there are two mistakes, my lord. First, my lord, as per our, my lord, understanding, my lord, that those works are not permissible under MG and Rega Act. First, my lord. The second, there is a mechanism, my lord,
for this MG and Rega cases, my lord. Mechanism that, my lord, that in the block level itself, my lord, under the district commissioner as DPC, my lord, during the work, my lord, they have to upload the bills. And after the completion of the work, they cannot claim any further bills. This is the mechanism, my lord, so that the fraudulent claims cannot come, my lord. And the ultimate power is with the government of India, my lord, because the MG and Rega Acts are under government of India, my lord. Now, in these cases, we have found, my lord, that they are claiming after the marking the work completion, my lord, complied. Thereafter, in that regard, my lord, we have filed our affidavit also, my lord. The government of India, my lord, said, my lord, if that situation happens, my lord, we have to.
Okay, we are in a contempt
my lord,
jurisdiction.
my lord.
I can't go behind the order.
Yes, my lord. That is why I am submitting,
I
my
can't
lord.
go behind the order. What you could have done is you could have filed a review. You have not filed a review. So that
Oh.
direction has to be complied with.
But my lord, that was only
You
for
can only
verification,
say
my lord.
That on verification, he is not entitled. His dues are there. On verification, his dues are not.
My lord,
This is the only.
in the verification, we found that he is not entitled, my lord.
Where is the order passed?
My lord, no direction has been issued to him. Direction was given to the project DC and BDO. Commissioner was not given any direction.
Money will come from the commissioner.
Then,
Government of India, my lord.
but order of this court.
Money will be come from government of India ultimately.
Now 3 and 6.
Three
Who is
and
appearing? You are appearing for 3 and 6 also. Who is the 3 respondent here?
3, my lord, 1 and 2, 2 and 3.
2 and 3.
2 and 3.
You are appearing for 2 and 3, Mr.
My lord, I have filed Wakalana for, I think, commissioner only, my lord, but
5
and
4
6,
5.
4 and 5.
4 5. 1 4 5.
But block development officer, I can appear, my lord, but I think she is not presently holding that post.
And what about respondent number 2?
2 has filed affidavit.
District commissioner.
What has he said?
He said, my lord, he is ready, but due to that problem, he is unable to.
That problem we cannot. That is why I am submitting, my lord. The government of India, without the permission of the government.
Without the review of that order, we cannot. That will be sitting on appeal of that order. Can't do that.
Even, my lord.
You file a review, get it
My lord, my
cleared.
lord, my lord,
I'll give you 2 weeks time.
my lord, my lord.
And if you loosen that review, that's the end of the matter.
My lord.
Even, my lord, in another case, same case, my lord, today, it was listed in court number 19. In that case, their argument was rejected by the honorable court. And
No.
final
Today,
opportunity
my
was
submission was that we need some more time. That was allowed.
But order was passed to a final opportunity to given, otherwise they will be there partially. That order.
Registry, Mr. S. Dr. Learned Counsel for the petition. Learned Counsel appearing for the respond number.
Respond number 4 and 5.
4 and 5 submits that. He be granted 2 weeks time to take appropriate steps in the matter. Pray accepted registry to list this matter again on 19/6/2026.
And that case is also 19. May I pray? It may be
Along with the
contempt case number 341.
341 of
2023.
2020.
Date
19.
19.
19.
That is also 19.
I am deeply obliged. Highly obliged, madam.
The order was NMB Chaudhary, Learned Senior Counsel, assisted by Mr.
K. Kashyap.
Huh?
K. Kashyap.
K. Kashyap, Learned Counsel for the petition. Mr. NNB Chaudhary, Learned Counsel for the petitioner, has submitted that the directions passed by this court by order dated 14/3/2024 in WPC number 4297/2023 has since been complied by the respondents. Also, accordingly, he submits that the present contempt petition be closed as having become infructuous. In view of the said submissions made by the Learned Senior Counsel for the petition, the present contempt petition, the order submission that the order directions passed by the said order dated 17/3/2026 in WPC number 4297/2023, comma, has been complied with, comma, the present contempt petition stands, course, as having become in the notices issued earlier stand recalled.
Much obliged.
Today, it's not all that will pass orders. Mr. Gogoi. Machine not working. We'll take it up on some.
Lordship, no issue, Lordship.
Mr. Chetri,
Lordship.
I wanted to pass the orders today, but all are totally, because the motion there, my mistake, I put it in.
Yeah, no difficulties, Lordship.
We'll pass it before the vacations. We'll give a date and pass.
Lordship, Lordship.
Paucity of time. Order to be registry to list this matter again. Still not convinced.
I thought that Lordship will be convinced.
Those judgments are on a different footing. I've gone through everyone. It's on a different footing. I came in the morning today. Still, it was troubling me. I recalled the file to my chamber and again read. Because I was in the mood in the morning to pass the orders.
Lordship will consider because